Marta. Good morning, Natalia.
Good morning, Hannah. Good morning.
Oh,
good to see
I'm
you.
so sorry. Good morning, Hannah. I was talking to you and I just realized that I was muted all the time. Very happy to see you. Can you hear us?
Very well.
Yeah. Okay, perfect. Okay, then we will start in 1 minute as planned. Thank you. And if anything, just let me know.
Okay, thanks.
Шановні колеги, партнери, доброго ранку. Зараз 10 година, тож будемо починати наш форум. Мені надзвичайно приємно вітати вас на 9-му міжнародному форумі з практики європейського.
I'm very pleased to greet you on the 9th International Forum on the European Court for Human Rights case law today. Event is expected in the legal community, and it's great that tradition of the forum continues in today's condition of distance communication. I hope that you were able to successfully connect to us. If you have any technical difficulties, please write into the chat. Our IT specialist will help you. And now I would like to give the floor for greetings to the ambassador to the project coordinator in Ukraine, Mr. Henrik Vilatsin. Please.
Thank you very much, Natalia. I hope that you can all hear me. Dear ladies and gentlemen, excellencies, I'm very happy to welcome you today at the 9th International Forum on the Case Law of the European Court of Human Rights. I would like to extend my gratitude to our partners, honorable speakers, judges of the European Court of Human Rights, colleagues from the Council of Europe, the Supreme Court of Ukraine, the National School of Judges, and the Franko National University of Lviv for excellent cooperation in promoting professional legal education and making this forum happen. Every year, the forum brings together judges and legal professionals from across Ukraine and abroad. Such a diverse audience of professionals allows to ensure fruitful discussions and to identify important developments in the European Court of Human Rights' case law. I'm glad that despite of the ongoing pandemic, that we managed to organize this event in an online format to further continue the dialogue on the topical issues of human rights protection. We recognize the fundamental role of legal professionals in safeguarding human rights and their constant work to improve the application of international legal instruments and standards. Aiming to develop sustainable human rights education for legal professionals and improve legal education, we promote incorporation of the provisions of the case law of the European Court of Human Rights as a part of the standard curricula for legal professionals and law students. We are grateful to the European Court of Human Rights for the fruitful cooperation in facilitating a dialogue with Ukrainian legal professionals. Every year, more and more people apply to seek justice, and the court remains true to its original intention to uphold the European Convention on Human Rights and prevent the abuse of human rights. It's a primary responsibility of national governments to safeguard their citizens' rights. To this end, it's crucially important to equip legal professionals with knowledge on the Convention's principles and the evolving practice of the court. This year's forum's topics include such issues as establishment of the effective cooperation with the European Court of Human Rights, issues of gender equality and access to justice, execution of European Court of Human Rights judgments, and other important topics. I sincerely hope that the information and experience exchanged during this forum will be your opportunity to combine efforts in promoting human rights protection standards and effective implementation of the rule of law in Ukraine. I wish you productive discussions, and I thank you for your attention, and have a good day. Thank you very much.
Дякую, пане посол. А зараз я хотіла б запросити...
Thank you, Mr. Ambassador. Now I'd like to give the floor to the head of department of the Justice and Legal Cooperation of the Council of Europe, Ms. Hanna Juncker, please. Ms. Juncker.
Thank you very much. Good morning, everybody. Distinguished partners and dear participants, I'm also delighted to welcome you to the 9th International Forum on the Case Law of the European Court of Human Rights. And I would also like to extend a warm welcome on behalf of the Council of Europe to all participants. And like Ambassador Willesen, I would like to express our really great appreciation to all the co-organizers and partners who have been involved in preparing today and tomorrow's event, and in particular to the OSCE. At the Council of Europe, we are always ready to support Ukraine in the application of the case law of the European Court of Human Rights and improving the institutions and procedures that relate to justice and human rights protection in line with the Council of Europe standards. It's the first time that we conduct this forum through video conference. It's great. I think that the organizers have decided to expand the outreach of the event by including a wider audience online than we would have been able to do if it had been a physical meeting, even if I very much regret not actually being in Lviv today. We are pleased, very pleased indeed, with the highly impressive level of speakers who will be contributing during these 2 days. And I would like to welcome the Vice President of the European Court of Human Rights, Ms. Ksenia Turkovic, and Judge at the European Court of Human Rights, Mr. Latif Husseinov, to today's event. In addition, tomorrow there will be a session devoted to the enhanced implementation of the convention at the national level, with, again, the much appreciated participation of another 3 judges from the Strasbourg Court who have found time in their schedules to join us. And finally, I would like to welcome our long-standing partners, the President and judges of the Supreme Court, the representatives of the Ukrainian judiciary, the representatives of the Registry of the European Court of Human Rights and of the Department for the Execution of Judgments here at the Council of Europe, and indeed all the distinguished speakers. Traditionally, this forum provides a platform for different groups, high-level officials, legal practitioners, academia, prominent think tanks and experts in the field of human rights protection to discuss different issues related to the application of the convention, including the most recent case law and the impact of the case law in Ukraine. This year, the forum will focus on challenges as regards the right to a fair trial under Article 6 of the convention, issues related to the execution by Ukraine of the judgments of the court, and the mechanisms for improving the interaction with the Strasbourg Court through the implementation of Protocol number 16. As you probably all know, the convention turned 70 in November, and it has indeed proven to be a living instrument that has evolved thanks to the interpretation by the court, and has enabled the protection of new and pertinent situations like gender discrimination, hate speech, the impact of AI, the environment, and so forth. And the last 2 issues that I mentioned, AI and the environment, are currently the subject of close reflection by the Council of Europe in our standard setting work. And once any such work is completed, that will again feed into the reflections and considerations of the court. So this is important work. The forum also gives us a chance to discuss the case law of the court and of the Ukrainian courts in the light of COVID-19. The pandemic has impacted all Council of Europe member states, and it has created a number of challenges to the application of the convention principles. The extent to which the justice sector has been transformed in a lasting way still remains to be seen, but clearly the pandemic has been a catalyst for very rapid changes in practice in all the member states. With the help of new technologies, countries have been able to confront some of the challenges caused by the pandemic and to turn them into opportunities. For example, access to justice has been greatly facilitated by online services that enable courts to conduct their hearings online, simplify the registration of cases, inform individuals more efficiently of their rights and of the procedures that are being followed. The pandemic has forced member states, in fact, to launch digital tools without which it would be impossible for them to perform day-to-day judicial tasks, probably during the pandemic. But, of course, these types of developments also raise questions about how to safeguard fair trial guarantees. And to partly answer that question, I would like to refer to an event we had on the 9th of November, organized by the Greek chairmanship of the Council of Europe. It was a conference by the ministers of justice, and they adopted some conclusions at the end. And they said, among other things, that digital justice and the allocation of more resources towards the public service of justice are some of the political actions that may improve the efficiency, professionalism, and transparency of the justice sector. And then it went on to say that human rights should be an integral part of any solutions that link technology and justice. In other words, when launching any measures, Member states always have to ensure the protection of human rights in line with the convention and the case law of the court. I focused a bit at length here on new technologies, but in fact, the forum will approach the implications and the implementation of the convention from many different thematic angles. I am sure that everyone will enjoy the presentations of the distinguished speakers, and I will stop here and wish us all an interesting and stimulating 2 days. Thank you very much.
Дуже вам дякую, пані Ханно. А зараз я
Thank you very much, Ms. Hanna, and I'm happy to invite the President of the Supreme Court, Ms. Valentina Dashevska. Thank you, Natalia. Good morning, dear Mr. Ambassador, Mr. Latsen, Ms. Juncker, Mr. Rector Melnik, Mr. Rector Onishuk, dear participants of the forum, moderators, speakers. I'm very pleased on behalf of the Supreme Court of Ukraine to greet all of you today, all those who convened to discuss the case law of the European Court for Human Rights. I would like to thank the co-organizers of this event. The Supreme Court supports the forum, the Lviv forum, since the very beginning, and although we're sad because we cannot meet personally, we cannot visit Lviv, but we recognize that in these conditions, online mode allows us to continue our work, our cooperation, and the most important, to continue our talk. The issues that will be raised by our speakers today during our session are extremely important for better protection of human rights at the national level and also at the general European level. Joint objective of the Supreme Court and the European Court for Human Rights is to ensure the best protection for human rights through interaction between the courts and through discussion between the judges, discussing specific topics and positions, understanding the approaches to solving some issues by both institutions. The consequence of this communication will be better perception and implementation of the positions, which in turn, in the midterm and long term, will lead to reduction of number of applications to the European Court. However, we realize that the reduction of applications depends not only on the work of the judges, because there are many systemic issues which we have to resolve in interaction with other branches of power. At the moment, the formalization of this interaction in Ukraine has already been accomplished. So we have the Commission on the Execution of the Decisions of the European Court. The Supreme Court is represented in this Commission, and it pays significant attention to the proceedings of the Commission. I'd like to share some developments in the area of execution of the decisions and in other areas of work in the framework of protection of human rights and freedoms that was performed by the Supreme Court. Last year, during the forum, we discussed that the work in the context of implementation of the standards of the Council of Europe and European Court for Human Rights has to be carried out in the following areas. First, the proper implementation of legal positions of the European Court formulated in the cases versus Ukraine and in the cases versus other countries. Prevention of infringements at national level, which has to become joint objective for the representatives of all legal professions, and also the removal of violations established by the European Court by ensuring the systemic execution of the decisions of this court. Over the past year, we had the progress in implementation of each of these objectives. Today, by the way, at this very time, we will have the committee hearings at the Parliament of Ukraine dedicated to the execution of the decisions of the European Court for Human Rights. The Supreme Court will also be represented at this session. We will inform you, will form the Council of Europe and European Society about what we are doing in this area. The Supreme Court, jointly with the Minister of Justice and the Department of Execution of the Decisions of European Court for Human Rights and experts of private justice, performed the analysis, the revision of the decisions of the European Court for Human Rights in the cases versus Ukraine, which are at the execution phase. It's proved that we had about 600 of these decisions. They are systematized by the articles of the Convention, which were violated. Approximately 40% of these cases are violations of the Article 6 of the Convention, the right for the fair trial. 30% are violations of Article 3 of the Convention, the prohibition for torture. Violations of other articles of Convention are more rare, but as a result, anyway, we have about 9% of violations of Article 8, the right for respect to the privacy and family life. About 8% are violations of Article 5, right for freedom and personal life, and 6% are violations of Article 2, the right for life. This grounded analysis gives Ukraine further areas for development at the legislation level and also at the level of work and interaction of the agencies responsible for execution. Also, this gives the area for development of the judiciary practice. However, the priority actions have to be done at the legal level. If we talk about case law, if we talk about development of the case law, this year the Committee of the Ministers of the Council of Europe stopped the supervision on the number of cases based on the results of examining of the case law of the Supreme Court, which showed that in Ukraine we had positive changes in the context of violations established in the cases like Lizanes versus Ukraine, Rynkovska versus Ukraine, East-West Alliance Limited versus Ukraine, Yakushev versus Ukraine, and MT versus Ukraine. The supervision on these cases by the Committee of Ministers of Council of Europe was stopped. The Supreme Court also performs monthly publications of the overview of case law of European Court for Human Rights, not only of the decisions approved versus Ukraine, but also the decisions on other countries, members of the Council of Europe. These overviews are publicly accessible at the website of the Supreme Court and also web pages in social media and in the messengers. And also we have newsletter which is sent to all the courts of first, second instance, and also this is communicated to the agencies which take care of the issues of legal policy and execution of the decisions of ECHR. Also, at the level of the Supreme Court, when we review specific cases, the Department of Analytical and Legal Work of the Supreme Court performs the selection of relevant case law of ECHR, which facilitates the work of judges when we look for the case law. And so these activities influence the level of awareness of the ECHR case law by the Ukrainian specific application of the decisions of ECHR when the judges review similar cases. No doubt. This is also promoted by joint activities like the one that we have today, like this very forum. Because through discussions we have approximation and perception of the positions of one another. I am pleased to be present at this forum which has become traditional, and I wish you interesting discussions, fruitful work, and pleasant discussions. Thank you very much for your attention. Thank you, Ms. Valentina, and now I pass the floor to the Director of National School of Judges of Ukraine, Mr. Mykola Onishchuk. Good morning, dear participants of the conference. Good morning, distinguished colleague who speak with introductions. In Lviv, we start the first freezing weather and we have snow, and we remember our good tradition to gather together for the next forum to discuss urgent issues of the European Court for Human Rights case law and execution of decisions. It's very positive that this tradition remains effective today now, although we will be working online, as the colleagues mentioned. Today, I'd like to say that with regard to the anniversary years in the activities of the Council of Europe, the Convention and the European Court for Human Rights, the system of execution of decisions, are one of the most efficient and effective mechanisms of the Council of Europe. I would say it is one of the most effective and efficient projects of the Council of Europe. And it's not by chance that the Convention today is the one that is seen by European Court for Human Rights when we feel it in with specific content, the principles of the Convention which are built into the European Convention of Human Rights.
It is exactly that determines the role of the legal legacy of the European Court for Human Rights, which has a very pronounced impact on the national legal systems, particularly when it comes to the protection of human rights and fundamental freedoms. In effect, it is the main area of human activity, legal activities, because the essence of the legal systems of national states is the human being and their values. And it is very good that this constitutional priority has been spelled out in the Constitution of Ukraine. ECTHR case law, even though the European Court has formulated its position vis-a-vis every article of the Convention, is producing new case law that reflects the developments in the human societies, industrialization, digitalization, productive relations, and founders of the Convention might not even imagine how wide the spectrum of the decisions and jurisprudence of the European Court might be in various aspects of the implementation of human rights and their protections. A year ago in Kiev, you might remember, we had a high-level conference on the practices and methodologies of judicial education in the implementation of the recommendations of the European Court. And in attendance were more than 20 national schools of judges of the European countries. I would also like to remind you that it was in November, on the 5th of November, that Ukrainian judges got access to the European system HUDOC that has got Ukrainian interface, which facilitates the access for monitoring of case law of the European Court by Ukrainian legal professionals, thus facilitating and thus benefiting from the case law legacy of the court. It pleases me also to note that Ukrainian judges just start referring to the case law of the European Court because they know this case law, and whenever they refer to those decisions or judgments, they do that meaningfully and very adequately in their opinions. I would also like to assure all participants of this conference, including esteemed Mr. Willitsen and Ms. Juncker, that all aspects of the application of the Convention in Ukrainian courts, practices and judicial education is an integral part of our work in the National Schools of Judges. Whenever we provide assistance in the application of the best practices of the European countries. I wish you all very good success, and I would like to thank Natalia and all of your colleagues for bringing us together, for making this a very good tradition to meet in November or early December. Thank you very much. Thank you, Mr. Onishuk. Now I will give the floor to Vice Rector of National University of Lviv, named after Ivan Franko, Mr. Andriy Kolyuk. Just the floor is yours.
Пане Андрію, скажіть, ви з нами, так?
Andriy, are you with us?
Що ж, шановні колеги,
That doesn't seem to be the case. So there is some technical wrinkles that we have to iron out, but we will move along our agenda, and we will start our first session, since the agenda is very busy, very intense, and after every presentation, you will have an opportunity to ask several questions of the speakers. You can do that either in the chat box, in writing, or and we will be working till noon in the first session. I'm very thankful to all speakers of today's conference. I wish you fruitful work, and we will be now discussing the implementation of European standards of the rights to a fair trial in the Council of Europe member states. And it is my great pleasure to give the floor to Vice President of the European Court of Human Rights from Croatia, Ms. Ksenia Turkovic, who will be speaking about case law on the European Convention of the Human Rights, framing international solidarity. The floor is yours, Ms. Turkovic.
I'm unmuted, I suppose. Thank you. Ladies and gentlemen, it is a great pleasure and privilege for me to have the opportunity to participate in the 9th International Forum and address members of the Ukrainian legal community. In this year, when we are celebrating 70 years of the European Convention of Human Rights, one of the most important instruments on human rights protection, not just at the European scene, but also on the global one, I cherish the opportunity to highlight the role of the court and its jurisprudence in framing and enhancing solidarity. Indeed, climate and environmental emergency, pandemic, COVID-19 crisis, the extensive presence of war across the world, growing economic inequality, unprecedented global migration, the threat of populism, globalization deepening existing and creating new forms of social vulnerability, all these challenges are posing a formidable threat to the enjoyment of human rights around the world, and none of these challenges can be properly addressed, nor the enjoyment of human rights could be optimized without enhancing international solidarity. While rights are claims we make on our own behalf against others, solidarity asks us to help those in our community who are in need. It is more than feeling, more than empathy. It requires action, proactive engagement with the rights of others, either in the common interest of identifiable group to which we belong, or out of our own sense of moral duty. Solidarity stresses community as opposed to rights which emphasize individuality, autonomy. Yet rights and claims complemented by duties of others, and thus solidarity and rights cohabit in supportive relation. Thomas Volcker of Rotterdam stressed already in 1790 that if a man supports only his own rights for his own sake, he does no moral duty. The European Convention mentions neither fraternity nor solidarity. However, notion of solidarity is embodied in the convention since its inception. The convention and the court, as an institution granting human rights protection, emerged out of social solidarity forged during the Second World War due to belief, as pointed out by Jean-Claude Trichet, that de facto solidarity would prevent atrocities and preserve peace. As you well know, this is not always happening, and the convention is not always successful in that respect, but we believe it does help. Solidarity is a fundamental moral and political value necessary for existence and protection of human rights. It serves as a foundation for content of human rights and the guiding principle for their realization. It provides basis for sharing burdens as well as advantages, and for assuming social responsibility to engage in collective struggle for justice and equality. Solidarity is reflected in the jurisprudence of the court in at least 4 ways. First, as I just explained, the commitment of contracting states to protect the worth and dignity of every person is in itself an act of solidarity. Creation and adoption of the convention is act of solidarity. Establishment of the court is the act of solidarity. Execution of judgments is act of solidarity. Second, solidarity imposes general duties in relation to application and enforcement of human rights norms guaranteed by the convention and the court's jurisprudence. Third, rights guaranteed by the convention serve as basis to derive protection for so-called third-generation rights or solidarity rights. And finally, the court is in effect protecting the right to solidarity itself. Some say that this is 4th-generation right. Let me first address the role of solidarity in the promotion and realization of the human rights guaranteed by the convention, classical, political, and civil rights. In the first place, solidarity is used in the convention system as an interpretive tool. It is principle having legal bearing on the interpretation and development of the rights guaranteed by the convention. It modifies the approach to be taken to the interpretation of particular rights. It influences and affects the content of human rights, filling gaps or modifying inconsistencies. For example, the court found in Getchev-Kantsev versus Germany that the social welfare schemes based on the principle of solidarity are not violating freedom of association. The court acknowledged recently in Nemeth versus Hungary solidarity as a justification for temporary limitation of property rights. A legislative amendment placed a memorandum on eviction during the crisis in Hungary arising from widespread defaulting on foreign currency denominated loans. This amendment resulted in the applicant not being able to take possession of the property that he had bought on the auction. Court perceived this amendment as expression of social solidarity that is balanced and not breaching right to property. Solidarity is as much a basis for the prohibition of discrimination as the equality principle. Solidarity and equality are mutually reinforcing. For example, the complaints related to various restrictions related to COVID are started to reach the court. And in solving them, principle of solidarity will be of paramount importance. Furthermore, states may invoke solidarity in order to justify a greater margin of appreciation in taking measures for the public interest. This was done in just mentioned Hungarian case. Also, Solidarity could be used as a justification to place the common good above the interest of the individual in performing balancing exercise by the court. This tension between social solidarity as a basis for state action and individual interest protected under human rights law is well illustrated by a Polish case, Hatynczapska versus Poland, which came before the Grand Chamber. The case concerned the claim that statutory rent control provisions laid down in Polish law violated Article 1, Protocol 1. The Grand Chamber took a position that social solidarity must be based on a fair distribution of burden, and thus the burden cannot be placed on one particular social group, however important the interest of the other group or the society as a whole. This case illustrates the way in which human rights law exerts a limit on the degrees to which states may rely on solidarity to justify interference with individual rights. In addition, there might be a tension between solidarity and other human rights principles, in particular liberty. This tension is resolved through the search for fair balance between the competing interests of the individual and those of the community as a whole or the group in question. In Sorensen and Rasmussen versus Denmark, case concerning Article 11 and the closed shop, the court held that although individual interests must on occasion be subordinated to those of a group, democracy does not simply mean that the views of the majority must always prevail. A balance must be achieved which ensures the fair and the proper treatment of minorities and avoids any abuse of a dominant position. Further, application of the principle of solidarity may tend to encourage expensive approach to interpretation of a victim status. Solidarity with those for whom access to legal redress is severely limited. Good example is the case involving disabled person who could not reasonably exercise her right to legal representation, Campeanu versus Romania. In relation to victim status, we will see whether the court will develop more permissive attitude towards public interest litigation, especially in relation to protection of the environment. The court just recently communicated the case lodged by several children against a number of European states for not meeting the standards to protect from the climate change. We will see whether the court will accept this more or less, and to a great extent, public interest litigation. Also, solidarity is used as a basis to extend extraterritorial jurisdiction of the court. In Alskeni, the court has emphasized that where the territory of one convention state is occupied by the armed forces of another, the occupying state should in principle be held accountable under the Convention for breaches of human rights within the occupied territory, because to hold otherwise would be to deprive the population of that territory of the rights and freedoms here to enjoy and would result in a vacuum of protection within the legal space of the Convention. However, the importance of establishing the occupying state's jurisdiction in such cases does not imply, a contrario, that jurisdiction under Article 1 of the Convention can never exist outside the territory covered by the Council of European Member States. On the basis of the principle of solidarity, also positive obligations are imposed on the state. For instance, the court found Czech authorities at fault where they separated children from their indigent parents because the latter could not provide an adequate family residence, emphasizing that the right to live together constituted the heart of the right to family life. The court held that it is the responsibility of the state to assure material assistance to such families. Valova and Vala versus Czech Republic. The positive obligation to prevent harm, when based on the principle of solidarity, it becomes clear that strict requirements of OSCE test, according to which state is under the obligation to prevent harm to life, when the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual, are not apt to regulate all situations where action of state is required. For example, the court found that insofar as reasonably possible, it is the state's responsibility to prevent harm to impoverished people living in unsafe conditions, even where these are living in illegal situation due to their extreme poverty. The recent Talpish judgment interpreted the requirements of OSCE test more flexibly in the context of domestic violence. In the court's view, the risk of a real and immediate threat must be assessed taking due account of the particular context of domestic violence. In such a situation, it is not only a question of an obligation to afford general protection to society, but above all, to take account of the recurrence of successive episodes of violence within the family unit. These were some of the examples how the principle of solidarity is contributing to interpretation of standard political
Це деякі приклади, як принцип солідарності
guaranteed under the convention. Let me turn now to protection of solidarity rights, third generation rights under the convention, such as the right to clean environment, peace and security, development, self-determination. These rights are based on the idea that they can only be realized through the joint action of all social actors, including states, individuals, and public and private entities. There is no autonomous right to solidarity rights under the convention. However, rights guaranteed by the convention serve as basis to derive protection for solidarity rights. The court interprets such rights as emanating from the core civil and political rights, right to protection of life, privacy, property, etc. I will briefly focus on two rights, right to clean environment and right to peace. You might say that the court has already developed rich case law on environmental protection. Various rights, primarily Articles 2, 3, 6, 8, Article 1, Protocol 1, have been interpreted to include the obligation of the state to protect people from severe environmental pollution, since pollution can affect individuals' well-being and prevent them from enjoying their homes in such a way as to affect their private and family life, Lopez Ostra versus Spain, or direct physical harm to the individual, Odgon versus Republic of Moldova, and so on. It may be fair to talk of an emerging special jurisprudence on environmental rights under the convention. The right to be free from environmental pollution exists whether the pollution is directly caused by the state or whether state responsibility arises from the failure to regulate private industry properly, Hutton and others versus UK. Where the court finds failure by national authorities to comply with some aspect of domestic law and regulation, it is easier to find violation. Direct harm is not always required. Some notion of state failure to perform its positive duties, whether by acting lawfully and transparently in setting policy, Tashkin and Okiaya versus Turkey, establishing a regulatory framework for environmental policy, Ugeli and others versus Georgia, maintain an environment free of risk, Disarno, is sufficient to find a violation of a convention. However, the court is facing a number of obstacles in adjudicating this type of cases. Locus standi, victim status, causation, burden of proof, whether and to what extent foreseeability of harm is relevant to liability or judicial relief, which are appropriate methods for awarding remedies, the interrelationship of competing claims from states, communities, and individuals, limitation periods for claims. For us, it is how we apply 6-month rule. Court could gradually address and more or less successfully resolve these issues. However, it would be easier for the court if special protocol would be passed defining human rights to healthy environment and preventing climate change. In such protocol, it is not sufficient to define the human right to healthy environment, but it would be helpful to address all these issues that make adjudication of these cases particular. As far as right to peace and security is concerned, since the early 1990s, the court has delivered hundreds of judgments in cases concerning forced disappearances and war crimes in which it has pushed indirectly for accountability. The court has slowly improved its ability to deal with large-scale human rights violations. Individual complaints have slowly evolved into a quasi-criminal mechanism, providing a complementary way of dealing with large-scale violations of human rights. By reversing the burden of proof, drawing inferences from the state's failure to cooperate, instituting priority proceedings, and ordering general measures under Article 46 of the Convention, the court has increased its capability to deal with these types of cases. We must not forget that to properly deal with evil, criminal prosecution and individual accountability are far from sufficient. We have to develop strategies and further enhance our ability to attend to the underlying structural causes of large-scale human rights violations. Social research, though still scarce, indicates that violations of civil and political rights, in particular abuses of personal integrity rights, discrimination, and denial of political participation rights, are closely identifiable as direct triggers of conflict or of its escalation. By protecting human rights in general, we are in fact preventing the occurrence of large-scale violations of human rights. Finally, I would like to turn to protection of solidarity as a human right. For the jurisprudence under the Convention, the question is it possible to derive a right to solidarity from existing rights? For solidarity to be a human right, it is necessary to identify the rights afforded to beneficiaries as well as responsibilities imposed on others. I dare to claim that the court is already in a way protecting right to solidarity as such by imposing legal duties on individuals and states to act in the interests of vulnerable groups, a duty to shield a variety of vulnerable populations. The court has explored the notion of vulnerability on several occasions and has referred to the vulnerability of certain groups and categories of persons in a number of its judgments and decisions. Notwithstanding, the concept of vulnerability and its legal consequences are still not clearly defined in the court's jurisprudence. I won't now elaborate further because I don't have time. But different categories of people that have been defined as vulnerable under the convention, and I won't go further into that, for different reasons, they are identified as such: socio-historical, intrinsic, or situational. These people are particularly susceptible to social exclusion, abuse, manipulation, corrupt influences, intimidation, coercion, exploitation, or various other sorts of ill treatment and human rights violations, either by state officials or private individuals, or are dependent on others for realization of their rights. For the very same reasons, they have specific needs, and thus their specific individualized circumstances have to be taken into consideration in order to provide effective protection and the guarantee of their procedural and substantive rights. This is exactly the essence of the right to solidarity. Furthermore, the court is expanding its case law on protection of victims' rights. it has accepted that positive obligations under Article 3 and 8 include the protection of the rights of victims in criminal proceedings, Y versus Slovenia in relation to victim of rape, A and B versus Croatia in relation to alleged sexual abuse of a child. This development could be seen from the perspective of right to solidarity as well. To conclude, when one looks at the jurisprudence of the court, how it uses solidarity to interpret civil and political rights guaranteed by the convention, and how it develops protection of solidarity rights, in particular, right to clean environment and right to peace and security, as emanating from civil and political rights, and how it is using the concept of vulnerability to protect actually the emerging right to solidarity itself, one gets the impression that the draft declaration on the international solidarity has been to a great extent inspired by the court's case law, in particular Article 2 of the declaration defining preventive and reactive solidarity, and Article 7 of the declaration regulating implementation of the right to international solidarity. What is missing in the court's case law is direct reliance on the principle of solidarity. Principle of solidarity should take more central and explicit role in the court's jurisprudence. Adoption of the Declaration on the Right to International Solidarity would facilitate this. Thank you very much.
Дуже дякую вам, пані Ксенія, за вашу доповідь.
Thank you very much, Ms. Ksenia, for your presentation. We have the first question. I'd like to remind the participants that you can ask your questions in the chat. So now I'd like to read the first question. Can we disseminate the principle of solidarity for the cases of armed conflict? And can we oblige the states to have positive duty to pay out the compensations to the victims for the damages, even if these damages were caused by a different state or different groups?
Yes, I was thinking and trying to conceptualize that actually quite a lot working on the court's case law. As you know, I'm coming from Croatia, and being a Croatian judge, I have a number of cases related to the war in former Yugoslavia, where we are getting different complaints related to the atrocities that were committed during that time. And of course, these cases are different from the cases that would come from Ukraine, or that are coming from Ukraine, because at the time when the war was in former Yugoslavia, the states of former Yugoslavia were not members of the convention, and thus we cannot go into the substantive violations, but we can deal solely with the procedural violations in this respect, finding not effective investigation. And then a number of cases that are coming then also related to the issue of compensation. And the court, at least it seems up to now, was not willing or was not able actually to go further from what is provided by the domestic law if prescription period has come into being. And that's the problem of the cases in this area, because for the most of the cases there is the period of prescription has arrived, and then the court cannot more or less cannot do anything. So I'm telling that for one reason, that actually it is important as soon as possible at the domestic level to start to deal with the issues of compensation, so that they can reach the court before the period of prescription arises. Because if the period of prescription is there, for the court it would be difficult to do anything. Then what is interesting, and we just yesterday adopted one case against Croatia, and it will be soon published, so most probably I might tell something about it, although it's not published yet. But in that case, it was interesting that the Constitutional Court of Croatia found a violation, substantive and procedural, for a violation related to the war crimes. And then that constituted the basis for the court to tell that there exists the obligation for the adequate compensation. So you will see, but I cannot go deeper into it at this point. So, so yes, you know, but what the court can do is quite, I would say for now, what we see in the jurisprudence, it's relatively limited. What the court can do is to grant compensation in the cases which are coming in front of the court, and the court is regularly doing that.
Дякую, пані Ксенія. Ми маємо ще
Thank you, Ms. Ksenia. We have one more question too. Tell me, please, is it possible to review as subjects for the right of solidarity and rights for peace and healthy environment, not the individuals, but the collective, maybe like humanity? Can they be the subject for these rights?
Yeah, that's really interesting, you know, question, and we will see how the court will position itself, because this case that I have mentioned that has arrived to the court this September, and it was quite a lot publicity about that case. I think 4 or 5 children from Portugal lodged a complaint against 34 or I don't know 30 or around 34 countries of Europe for not meeting the standards for preventing the climate change, and more or less this is a complaint, as you say, not only as individual right, but it's also complained as a collective right. But for now, what we have is that the court is requiring some connection of the victim to the harm for the victim to be able to lodge a complaint. And this is a big question, and that is why I have said that it would be important for the protocol on the right to clean environment to be drafted and then to be adopted, because through that protocol then the victim issue in relation to the environmental rights could be expanded and maybe solved differently than it is for the other rights, and which would give the court a greater possibility to deal with these issues. Although, you know, the court most probably as a living instrument, as the convention is the living instrument, the court is always trying to find the ways, you know, how it could actually expand to a certain extent, where it is necessary, the possibilities to deal with the new problems and with the new rights, as we have seen that in the area of the environmental rights. Actually, the court has developed quite expensive case law in past 10 to 15 years.
Пані Ксенія, дуже вам дякуємо за вашу доповідь.
Ms. Ksenia, thank you very much for your presentation. We have to move forward. And before we move to the next speaker, we decided to solve our technical problems. I'd like to pass the floor to the representative of one more partner who had the idea of this forum. And I'm pleased to pass the floor to the Vice Rector of Lviv National University, named after Ivan Franko, Mr. Andriy Gukaluk, please. Mr. Andriy.
Ну що ж, виглядає так, що...
It looks like we still have technical problems. They're not quite resolved, so let's move forward, dear colleagues, as now we have more than 280 participants with us who joined in Zoom and also at YouTube channel. So we move to our next speaker. I'm pleased to give the floor to the judge of the European Court of Human Rights from Azerbaijan, Mr. Latif Kuseinov, who will make a presentation on abuse of rights of claim in the European Court for Human Rights. Please, Mr. Latif.
Good morning. Do you hear me?
Yes, we can definitely hear you.
And you hear me and you see me?
Yes, perfect.
So dear participants, dear colleagues, it's indeed my great pleasure to participate already for the third time in this important conference, which takes place annually in the marvelous city of Lviv. I'm grateful to the organizers for the invitation extended to me. For this year's presentation, I've chosen a subject which has nothing to do with the substantial issues of human rights protection in Europe. So this is very much different from the topic of my esteemed colleague, Vice President Ksenia Turkevich. My topic today is rather on a procedural matter, abuse of the right of application to the European Court of Human Rights. In the European Convention on Human Rights, we can find two articles where this concept of features. It's Article 17, prohibition of abuse of rights, and Article 35, paragraph 3a, which is abuse of the rights of application, of individual application. I'm not going to speak about Article 17, which is, this is a different topic. I will speak about Article 35, paragraph 3a, namely the abuse of the right of application, which is one of the procedural criteria of admissibility of applications before the court. That said, there is a link between these two provisions. Thus, where an applicant seeks to vindicate his or her convention rights in a way that blatantly violates the values and rights protected by the convention, such conduct may qualify as an abuse of the right of individual application. In one case, from 2017, Koch against Poland, the applicant used force to pull out hair sample from both his former wife and his daughter, trying to prove that he was not the father of the girl. And he delivered these samples to a private laboratory, and the DNA test results confirmed that the applicant was not the father of the girl. The court, our court, having regard to Article 17, found that by relying on Article 8 before the court, on the basis of evidence obtained in violation of other people's convention rights, in this case, the former wife and the daughter, the applicant had abused his right of individual application. You all know that for a person alleging a violation of his or her rights before the Strasbourg court, it is not so easy to have his or her case examined on the merits. There are, I would say, there are a number of doors, one after another, that you have to pass through. Let me put it like this. There are queues in front of each door. The queue in front of our door, which is the issue, not the admissibility criterion that we are examining now with you, abuse of application. abuse of the right of application. So the queue before this door is the shortest, which means that not so many applications submitted to the court are declared inadmissible on this ground. One of the reasons is that it is not so easy to identify the intention of the applicant to mislead the court, which is a key element, especially at an early stage of the proceedings. The court has stressed that dismissal of an application for abuse of the right of application is an exceptional procedural measure. According to the court, any conduct of the applicant that is manifestly contrary to the purposes of the right of individual application, as provided for in the Convention, and impedes the proper functioning of the court or the proper conduct of the proceedings before it, constitutes an abuse of the right to application. Even if the government does not raise this preliminary objection, this objection of inadmissibility, you know that the Convention, the governments usually raise one or more objections to admissibility of the application in question. So even if the government does not raise the alleged fact of abuse of the right of individual petition, this question can be raised by the court itself on its own initiative. So it's like the 6-month rule, which as you know, which can be raised by the court itself. For example, in its recent decision on Georgian and others against Armenia, where the applicant had not informed the court of new developments that had occurred during the proceedings before the court. So the court, based on that ground, found the application inadmissible. In its case law, the court has identified 4 categories of situations concerning abuse of the right of application. So abuse of the right of application may arise in different situations. If to look into the case law of the court, so we can identify 4 such situations. So the first is applications involving outright dishonesty, or at the very least serious negligence in relations with the court. Here, it means that the applicant knowingly wishes to mislead the court by providing untrue information, untrue facts. But a conclusion that the applicant has intentionally misled the court must be established with sufficient certainty. For example, in a Ukrainian case, Zelenchuk and Tsutsura, I hope I pronounced well, the court did not find this intention. The intention that the first applicant had not informed the court that she had rent out her land. Let's look at the examples, where in which this issue has arisen before the court. For example, applications, as already said, applications knowingly based upon untrue facts. In one Georgian case, for example, we have several examples on this category. The applicant submitted an application on behalf of one of the applicants who had died several months ago. Although it was unclear who exactly sought to deceive the court and falsified the signature on the authority form, but the consequence of this misleading procedural manipulation was incompatible with the purpose of the right of individual application. Another example, application submitted under a false identity. In one case against the Netherlands, the court discovered that whereas the applicant had presented herself as a student, as a minor, as a young lady, but the court had discovered that the person under the name of Drifhut, this is under this name, the application had been submitted to us. So the person under this name was 59 years old, man. And the representative of the applicant told the court that his client had no valid identity document for ideological reasons. So here the court, of course, found this application inadmissible. Another example, falsification of documents. For example, in one case, the medical certificate from the prison had been falsified. Then in one case against Netherlands, two Iranians, they had falsified a judgment and a summons from Iranian tribunals. And in a recent case against Ukraine from last year, Sevruk against Ukraine, the applicant died in 2013, but power of attorney allegedly given to the lawyer, to the representative, dated 2019. No, I think Sevruk, Ukraine from this year. So here the court, of course, they found again inadmissible on the ground of abuse of the right of application, because that was forged document. Another example, a failure by the applicant to inform the court of essential evidence. Rule 47, paragraph 7 of the rules of court require the applicant to provide notification of relevant developments. For example, the court, the domestic court decision, for example, was executed, but the applicant did not inform of this fact the court. In another case, there was a constitutional court decision having re-examined the case of the applicant, and the same was in the Armenian case I mentioned earlier, and the respective applicants had not informed the court of these developments, and the court found those applications inadmissible. There was a case against Portugal when there was the husband and the wife, they had a similar complaint. The applicant had submitted his complaint about length of proceedings. So in which both of them had been involved, the same complaint, the same issue, but they submitted their complaints to the court separately. The husband submitted his complaint, and the court examined it, and the court adjudicated, awarded satisfaction. And then the wife decided to come to us, and the court discovered this and found the application submitted by the wife inadmissible on the ground of abuse of the right of application. Here we should mention a Grand Chamber case, Gross against Switzerland. This is also about misleading the court, knowingly misleading the court, slightly different. It's a Grand Chamber case. Interestingly, here the applicant complained, relying on Article 8, that the Swiss authorities, by depriving her the possibility to end her life, and by not allowing her to take the lethal dose of sodium pentobarbital, so that the Swiss authorities had violated the applicant's right to decide by what means and at what point of her life, at what point and by what means her life would end. The applicant was able to realize her wish, that means to take this lethal dose, in 2011. The chamber, having no information about this, examined the case in 2013, so 1 year and a half later, and decided by majority that there was a violation of Article 8. And then when the court, the government learned of this fact in 2014, and then the case came before the Grand Chamber at that point, and the court said that although the applicant's representative told the court that they had no information about the death of the applicant because, in fact, he had no direct contact with the applicant. It was his intermediary, and that person didn't wish to inform the applicant's representative of this fact because feared that it would lead to discontinuation of the proceedings. So the applicant's, although the applicant's representative was not aware of the fact, the court said that first, that was failure of the applicant to effectively protect his client, according to the rules of court. So that was one of the failures. And the second, which was important, that the fact that concerned the very core of the matter underlying the complaint was not submitted to the court. So the court declared that the application at Grand Chamber level inadmissible on this ground. So this formula has been referred to by the court subsequently on several occasions. So that means the very core of the case, and sometimes on this basis, the court, when the court found that the misleading information, if it is not related to the very core of the case, the court found that there was no breach of this rule of 35 paragraph 3a. So, and accordingly, the court found the application admissible. In one case, in Bulgarian case, which was examined 3 years ago, the government argued that the first applicant had abused his right to individual application, because he had submitted medical certificate about alleged ill treatment from an expert which which was not a medical practitioner and which was not medical practitioner. And the court also found out that this person was the applicant's sister. Yes, the court said that it was this misleading information. First, that the person was not a medical practitioner, and the second, which was also very important, that was the applicant's sister. But this fact, this misleading information, was not related to the very core of the case, because the applicant relied on other evidence in order to corroborate his complaints about ill treatment. So he had another statement by medical experts. He had statements by a care assistant. He has statements from other applicants, but the court found that the application was not inadmissible, but added that in any case it would not take into consideration the applicant's sister's statements concerning the alleged ill treatment. The applicant is entirely responsible. The court has said it many times. The applicant is entirely responsible for the conduct of his or her lawyer or any other person representing him or her before the court. Any omissions on the representative's part are in principle attributable to the applicant himself or herself and may lead to the application being rejected for an abuse of the right of application. In the case of Bekauri against Georgia, where the applicant's representatives did not inform the court of the key developments in his situation, I apologize, the representatives did not inform the court of the key developments in his client's situation, especially the first representative. She had failed to submit observations on the admissibility on the merits, despite the extension of the time limit for submission observations. Then she had lost the materials of the case, and she had failed to cooperate with the applicant's other representatives, and apparently she had left the applicant's family in ignorance as regards the developments of the case. The court said that the conduct of the applicant and of his representatives, in particular the conduct of the first representative, was a vexing manifestation of irresponsibility. The court stressed the role of lawyers in the following terms. In general, lawyers must understand that having due regard to the court's duty to examine allegations of human rights violations, they must show a high level of professional prudence and meaningful cooperation with the court by sparing it from the introduction of unmeritorious complaints, and once proceedings have been instituted, then meticulously abide by all the relevant rules of the procedure and urge their clients to do the same. Otherwise, the willful or negligent misuse of the court's resources may undermine the credibility of lawyers' work in the eyes of the court, and even, if done systematically, may result in them being banned from representing applicants under the rules of court. The first case I'm aware of, was a case against Serbia, Petrovic against Serbia, 2011 or 2010, when the lawyer was permanently banned from representing clients, from representing applicants before our court. for having knowingly misled the court, for having, I would say, bombarded the court with applications containing untrue facts, untrue information. The other case, probably there might be some other, but I know two such cases. One, I said, this Serbian lawyer, and the second is, unfortunately, you know this case, is a Ukrainian lawyer who was banned 2 years ago and permanently from representing applicants before the European Court of Human Rights. And in two cases against Ukraine, the court referred to its decision on ban. So reminding of the fact that the court had to resort to this measure in order to protect itself from such applications with vexing manifestations of irresponsibility on part of the applicants' representatives. So here, this one case is Chepelenko and others, 2020, and the other one, Beskrila, from 2019. These two cases where applications were lodged in the name of deceased persons. Even where the court judgment on the merits has already become final, but it subsequently transpires that the applicant had concealed a fact which would have been relevant to the examination of the application, the court is able to reconsider its judgment by means of review, this Rule 80 of the Rules of Court. By means of revision procedure, even after its final judgment. The court has done it in a number of Romanian cases. So revision of a judgment is possible only if the respondent government could not reasonably have known of the fact in question at the time of the court's examination of the case. And if the respondent government submits the request within 6 months, so this is a procedure rule under Rule 80 of the Rules of Court. Second category of situations where applications can be found admissible on the ground of abuse of the right of application is where the applicants use particularly vexatious, contemptuous, threatening or provocative expressions in their correspondence with the court. In one case, again, Czech Republic, Rehak, the applicant used really insulting expressions against the entire court, against several judges, against the registry, especially the Czech lawyers, accusing them of political crimes. And the applicant systematically contested the impartiality of the judges of the court, members of the registry, and the court held that the applicant's allegations are intolerable, which exceeded the bounds of normal criticism and amounted to contempt of court. In one Russian case, this Zhdanov and others from 2019, one of the applicants had already lodged an application with the court and won the case, but he was not awarded any just satisfaction. This is Alexeyev. His name is an LGBT activist, head of Gay Russia. He, in his in social networks, he heavily insulted the judges of the court. You can probably find it on social networks, expressions extremely insulting. And the court said that language used by the applicant went beyond the bounds of normal civil and legitimate criticism, and here the court found his application, so the application concerning that person, Alexeyev, that part of the application was found inadmissible, but the court continued the examination of the complaint concerning the other applicants. In another Russian case, Alexanyan, it's about his medical treatment case, Alexanyan had used, his lawyer had used in his observations expressions like the government falsely asserts, the breathtakingly irresponsible statements made by the government. The Russian government qualified these statements as an abuse of the right of application, but the court noted that these statements reflected the applicant's, the lawyer's emotional attitude towards the behavior of the authorities in his client's case. And these statements are value judgments, and this, as such, they cannot be regarded as untrue. So they are not, in the eyes of the court, they are not insulting or provocative. So the court did not find those statements as an abuse of the right of petition. If an applicant had made provocative, insulting statements, but then subsequently, especially after the intervention of the court or registry, after warning, had corrected, had withdrawn and withdrew his statements, those statements, and even it maybe brought apology before the court may decide not to find that application inadmissible. So by taking into consideration the applicant's this behavior, that was a case Chernitsyn against Russia. So the court took into account that yes, in fact, there had been offensive remarks against the government's representative, against the government, but against not only, but also against politicians, lawyers, law enforcement authorities of Russia. The court took into account that after the warning made by the court, a formal warning, the court, the applicant withdrew his offensive remarks and offered an apology to the court and to the respondent government and the representative of the government. So the court held that the grounds which might have led to a decision on admissibility on the ground of abuse of right of application have ceased to exist. Third category is when the applicant breaches the confidentiality of friendly settlement procedures. You know that friendly settlement procedure under the convention and on the rules of court is confidential. And if the applicant's lawyer, they publicize these confidential negotiations between the court, between the parties, and then the court may declare the application inadmissible. There was one Bulgarian case and a Russian case, Eskerkhanov and others, Russia, and I think 2017, and one Ukrainian case, Burlakov against Ukraine. But in the last case, Burlakov, the applicant informed not Ukrainian authorities, but Russian authorities of the friendly settlement procedure with the Ukrainian authorities. And in these cases, the court found those respective applications inadmissible as abuse of the right of application. And the last category, when complaints consist of petty, vexatious, and manifestly ill-founded applications that are similar to earlier submissions already declared inadmissible by the court. It happens. I must say, even not rarely. As single judge, I see such applications that several times the applicants the applicants come to us with really very petty issues, with vexatious state submissions, manifestly founded complaints, sometimes dealing with really issues like, for example, there is no light at the bus stop, with such kind of very tiny, minor issues, and the court probably displays tolerance for first time, second time, but then there is a formula, a letter sent to this applicant by saying that if you continue bombarding the court with these complaints, then we will not examine, we will not admit your complaints. And usually already at the single judge level, such complaints are declared inadmissible on this ground. Before entering the force of protocol number 14, when the new admissibility criterion was added, no significant disadvantage, you know this, significant disadvantage. There have been cases when the court found applications inadmissible on the ground of abuse of the right to application, when the damage, pecuniary or non-pecuniary damage allegedly suffered by the applicants was really very minor, or there was no disadvantage, and the court at that time found those applications admissible on this ground. But now we have this NSD, the no significant disadvantage criterion. The court resorts to this criterion for declaring inadmissible respective complaints. I've exhausted my presentation. I apologize. I don't see the reaction of participants. Unfortunately, this is very important for me as I'm professor by background. So this is the reaction. I don't see the reaction. I don't know whether they are following me after this very lengthy presentation. I hope that the participants will not find sufficient grounds for declaring this lengthy presentation as an abuse of my right to make a presentation before you. Thank you very much for your attention.
Дякую вам, пане Латіфе. Дякуємо вам за щорічну участь.
Thank you, Mr. Latif. Thank you for your annual participation in the forum. We have questions to you. If the person A finds out that in the European court there is the case filed by person B, and the person B writes in the application the wrong data, do you see the opportunity for the person A to inform about the abuse of the rights of the second person to the higher court? If yes, then what is the procedure for this?
It seems that I've understood, I've understood, but not all. Could you please repeat?
If the person A get to know that the European Court of Human Rights is considering the case which was submitted by the person B, and the person B provided in the application non-truth facts and data, do you consider the opportunity for the first person A to inform about such abuse of the right of the second person for the high court, in the court? And if it's so, what would be the procedure for this?
Understood. Because in fact, no, I wanted you to repeat it in Ukrainian, but you said it. Thank you very much for having translated it. Yes. So I understood that person A is like whistleblower. So because when you said it in Ukrainian, I understood that probably it's also potential applicant. So this is not a potential applicant, possibly. This is just a whistleblower, an honest person which cannot tolerate any dishonesty before the court, that how can a person, my compatriot, can irritate the court by, or can mislead the court by submitting untrue facts. Yes, I think, of course, there is no formal procedure. Any person can inform the court of this, or simply, maybe even much more simple way is just inform the government agent, which is, of course, in permanent contact with the court during the whole entire proceedings concerning the case in question. So a person may inform the government agent, and the government agent then will submit it properly in an appropriate way. There are channels for that because they come, as I said, this cooperation must be valid and remains valid during the entire proceedings until the examination. Even I said, and until the examination of the case. So abuse of the right of application is not just a procedural criterion, requirement, but also very important obligation of cooperation of parties before the court. So if you do not cooperate, this is the only admissibility criterion for not respecting which you can get a sanction. I mentioned this, being banned from representing persons. So here, our whistleblower, our honest person, can inform the government agent or can send a letter to the court. Because as I said, the court can itself get involved into this issue and can proprio motu raise the issue of abuse of the right of application.
Дякую вам, пане Латіфе. Ми отримаємо дуже гарні відгуки від учасників.
Thank you very much. Mr. Hussein, we receive a lot of wonderful appreciation of your presentation. Now I will still give the floor to Mr. Andrei Gukaluk. Thank you very much, Natalia. Good morning, everybody. It is my great pleasure to greet all participants of the 9th International Judicial Forum in this quite unusual format. And I hope that we all will be even glad to see many more participants that any auditorium could actually accommodate otherwise. Lviv University is one of the organizers of the forum, and we hope that the 10th forum will be hosted by university in our usual mode, and we will have an opportunity to meet with you in person, develop case law, develop our best practices. And since we treasure your presence in the university, I hope that we will all benefit from these technical advantages that we have today. And next year, I invite you to attend the 10th forum in person to improve our own practices and contribute to the improvement of case law of the European Court. Thank you very much, Mr. Gukaluk, for being the co-host, co-organizer of this forum. I would like to give the floor to one of the co-founders of the forum, Justice of the Supreme Court, Mr. Gudima. He will be speaking about certain aspects of the application of Article 6 of the European Convention on Human Rights by the Grand Chamber of the Supreme Court in Ukraine. Good morning, dear colleagues. I hope you can hear me and you can see me, and I'm grateful to the organizers for, first of all, putting it together and for inviting me. And I hope that in the years to come, this condition will survive. I will put up the presentation related to certain challenges that we faced in Grand Chamber of the Supreme Court while applying Article 6 in our case law.
Єдине, що чи добре видно?
Can you see my screen now? Yes, we can. Thank you. So first of all, I would like to discuss with you additional individual measures applied by the Grand Chamber to execute judgments of the European Court. First of all, let us talk about the cases that the Grand Chamber considered in 2020, and my focus will be on the decisions adopted in 2020. First of all, let us focus on case Yakushenko versus Ukraine. In this case, Ukrainian national courts did not motivate their decisions. They ignored the argumentation of the applicant without leaving them without any assessment, and actually they declined consideration of the evidence present in the case, nor did they look into the evidence provided by the plaintiff, by the applicant. When we looked at this case in the part pertaining to the individual measures, we decided that in this situation, the judgments were not duly reasoned, and the reasoning was not related to the application of a procedural and a substantive law and the assessment of evidence or examination of evidence and facts, which only the trial courts and courts of appeal can do. The Grand Chamber decided to reverse the judgment and to send the case for consideration by the trial court, by the first instance court. Another case, criminal case, and we've got a number of such cases related to rights protected by Article 6. We considered several such cases in 2020, one of them being Golovko versus Ukraine. A whole set of violations took place there with regard to rights protected by Article 6. That's access to counselor, during the first questioning and during the investigative action, and impossibility to get access to the counselor hired by the applicant's wife, and ignoring some evidence and evidence obtained illegally. So all of those violations were established by the ECTHR, and we had to respond. In the situation whereby all the evidence on the basis of which the person was convicted was collected with violation of the right to protection and for the legal counseling, such violation actually impact the overall justice of court proceedings, and the set of evidence which is left once the evidence obtained in violation of the procedure are eliminated. So does not allow the court to either prove or disprove the guilt of the defendant. So there is no other way to of redress than the repetitive or the new proceedings in the trial court. So the Grand Chamber reversed those judgments, and these cases will be retried. A more complex situation is observed in case Yanko versus Ukraine because of the reasoning in the ECTHR judgment. In this case, which is to a certain extent similar to the previous one, ECTHR established the violation of right to legal assistance or to access to legal assistance, but it also established that authorities did not explain their rights and the legal implications. They did not provide the legal counsel when he admitted committing certain crimes. And the domestic courts used this admittance of guilt. The European court used a very interesting formula saying that the Ukrainian court did not convincingly prove that the general justice of the criminal proceeding was not irreversibly violated by stating that the European Court for Human Rights in paragraph 75 of that judgment described several circumstances pointing to the fact that proceedings in the case of Mr. Yanko were justified and were fair. Just on the one hand, the European Court states in certain aspects the fairness of the proceedings with regard to the applicant who committed crimes in the investigation of which certain violations of the convention occurred. And on the other hand, the European Court showed that the government failed to prove that the fairness of the proceedings were irreversibly violated. So the Grand Chamber had a dilemma what to do, whether to reverse the entire decision and the entire set of the sentences and judgments, or to do that only in a certain part. So in the ruling of the 1st of September 2020, the Grand Chamber of the Supreme Court, pursuant to the judgment of the European Court, so that according to the materials of the case, evidence obtained during the investigation in the presence of the applicant were not actually did not ensue from the limitation of his access to legal assistance. And these pieces of evidence actually repeated what the applicant admitted to. But the situation of Sianko is different from that of Siensky and Tchaikovsky versus Ukraine or Zakchevsky versus Ukraine. Applicant Sianka, unlike applicants in two other cases, did not actually reject or did not deny his admittance. And moreover, he cooperated with the investigators and provided additional information that he did not provide without legal assistance. Our chamber also noted that Sianko was not limited in his ability to object against certain evidence or dismiss certain evidence, and it pointed to paragraph 75 of the European Court's judgment, pointing to the parts where the judgments were, the national court judgments were fair. So we decided that certain referrals to the references to the evidence that run counter to the judgment of the European Court should be eliminated from those decisions. Another case, Chernika versus Ukraine, whereby the European Court stated that in that case, the applicant was convicted based on the testimony of witnesses absent during the examination of witnesses. And moreover, only one of the three witnesses that were key witnesses in that case was examined during the preliminary trial in the first instance court. So the principle of immediacy was not observed. Other witnesses were not examined by court, either by the judge who considered the case in the first instance or not in the Court of Appeal. Moreover, the European Court pointed to the fact that there were no guarantees to ensure the correct understanding by the new judge of testimony by the absent witnesses and the testimony received by or statements made by the witnesses in the preliminary hearings. So, and in this case, the European Court pointed to the violation of the general fairness of proceedings. And in this case, there was no other way than establish that the inconsistency of proceedings, but to reverse the court decision. But the question was whether this reversal should pertain to the decisions of all court instances or only to the Court of Appeal or a cassation court. And given that, since this case was considered by national courts very long ago, and based on the decision of the first instance court, will actually violate the principle of reasonable time, and it was impossible to examine or take statements from other witnesses that were absent during the trial. So the court should ensure redress to the violations established by the European Court by examining the 3 witnesses that were not present, or by studying their statements, relying on the sources available to the judge. So this case would not be sent to the trial court according to the judgment of the Grand Chamber, since a long period of time has elapsed since those events. And it was not likely that all of the witnesses could be summoned, not only those 3, but others as well. And they might have difficulty reconstructing the events and circumstances of the case. In the case Alexeyev and others versus Ukraine, the European Court established that the National Court did not make sure whether the case was served to the applicant and whether he was notified properly in any other way. The European Court stated that in this case, the court deprived the applicant from responding to the decision, which is called appeal case. And as a result, the European Court established that the state failed to fulfill its obligation under Article 6 from the principle of equality of arms. And the Grand Chamber had to reverse this judgment. The judgment was reversed and the case was sent for a retrial. So it's not always that application to the Grand Chamber under exclusive circumstances can be the case where we should take additional measures through the review of court decisions. And I will tell you about these cases. Oftentimes, applicants come to us with the application to seeking revision of those decisions when they are not entitled to that. For example, when they never applied to the European Court of Human Rights, but they saw a judgment in a similar situation of an applicant, which might be similar to that. But in view of this case, when they see a seemingly similar situation, then the applicant believes that he should apply to the Supreme Court, seeking revision of the National Court's judgments. In this case, the Grand Chamber does not admit such applications. and you will see all of the data with regard to the cases that we considered. Then when we find cases inadmissible, is when the European Court for Human Rights considered the case of this very applicant who comes then to the Supreme Court, but the applicant does not consider the contents of the judgment of the European Court and the violations established by the European Court. Oftentimes they come to us seeking revision of their court decisions when the European Court established the violation of the reasonable time principle, or just the detention in custody during the proceedings. In such situations, it's evident that one cannot state that there was no fairness with regard to the applicant. In such cases, in such situations, when the European Court's judgments are about the time frames either of the proceedings or of detention in custody, a Grand Chamber usually finds these cases inadmissible, believing that in this case, we cannot provide redress to the applicant. Sometimes the applicants do not fulfill the judgments of the courts on non-consideration of the case. Applicants often do not point to the link between the judgment of the European Court for Human Rights taken in a certain situation and the situation of the applicant him or herself, and do not say what they expect from the Supreme Court in the case they go to such courts.
Sometimes the terms are violated. It's envisaged by the procedural law on review of court rulings according to exceptional circumstances when the decision on dismissing the application is not fulfilled. The Great Chamber of the Supreme Court returns the application to the applicant. In the situation when the term for applying the application is violated, so the applicants often do not justify by the good reasons the missing of these procedural terms. On the screen you can see some court decisions when the Great Chamber of the Supreme Court believe that there are no good reasons for extending the missed procedural terms when the individual applies with a request to review the court decision after the decision of the European Court for Human Rights, after half year, after 1 year, or even longer. At the same time, the person knew about the decision of the ECHR, but for a long period of time they did not apply. Now let us discuss a little bit other aspects of Article 6 and the equality and competitivity of the parties, not in the context of execution of the decisions of a CHR, but in the context of national judiciary practice. In 2020, the Great Chamber of the Supreme Court had the case with the concept of negative proof, negative burden of proof, which is often used by the courts. We talk about the situation when one of the parties, the claimant, states the presence of some facts, they do not prove these facts, and another party does not object against these facts. In the court decisions, there are cases when the courts write that as the defendant does not object or does not prove the opposite, then the fact which was stated by the claimant is established. So the Great Chamber of the Supreme Court mentions that this approach to prove when only one party has to confirm the presence of the fact, not proving this, and another party has to object the fact with evidence, the concept of negative evidence will violate the principle of competitivity and will create an excessive burden of proof to one of the parties that have to object the evidence of another party. The Great Chamber believed that the concept of negative evidence cannot be used by the national courts. As regards the third aspect, which is covered in this presentation. This is the right to access to the court. We have often cases in the practice of so-called jurisdictional conflicts when one of the judges refuses to open the proceeding on the case, believing that the case has to be reviewed by another court, by a different jurisdiction, or they dismiss the proceeding on the case, believing that the case belongs to the jurisdiction of another court, and another court to which the applicants filed action also believes that this court also doesn't have to review this case. In this jurisdictional conflict back in 2018, the Great Chamber of the Supreme Court formulated the idea that we cannot block the access of person to the court in the situation if one of the courts already refused to review the case and another court says that according to the procedural law, the case does not belong to their jurisdiction. In this situation, the Great Chamber mentions it as the second court to which the person applied to fulfill the decision of the first court. The second court has to review the case even if the jurisdiction is not proper. They have to mention in the text which jurisdiction had to be. But to avoid the jurisdiction conflicts, the case review should be continued. This case has happened on multiple occasions, and this approach of the Great Chamber is targeted at fulfilling the number of decisions of ECHR versus Ukraine, which happened earlier when the presence of jurisdiction conflicts blocked the access to justice for the individual. It made it impossible to have access to fair trial in all jurisdictions, in all courts of all jurisdictions in which the case could have been reviewed. Also, I'd like to draw your attention to a special situation which also created problems in our practice. This is the situation when the court, in particular, the Cassation Instance Court and Great Chamber, the Supreme Court, dismissed the proceeding on the case. This dismissal, until recently, was linked to the necessity of the claimant to file new action to the court of the proper jurisdiction. The Parliament corrected this disadvantage in the regulation, and in February this year, as you know, the changes to procedural law entered into force, and today we have the duty of the court, which dismisses the proceeding on the case, first to explain to the claimant to which jurisdiction this case belongs to, and if the dismissal is happening in the appellate or cassation instance, then in addition, we have to explain the rights within 10 days after receiving the notice of the Court of Appellate Cassation instance on dismissal of the case. They can apply to the court with application to refer the case to the established jurisdiction. And the Great Chamber of the Supreme Court on multiple occasions within 2020, when dismissing the proceedings on the case, satisfied the motion of the claimants on transfer of the case to the court of the appropriate jurisdiction. The last in the block which I would like to mention is that we have issues related to the quality of procedural law and to the formulations of the provisions enshrined in the laws. For example, there is a case on ability of the cassation challenge of the motions to support the claim. The conflict is based on the facts in which way to apply the appropriate provisions of the procedural law, which clearly do not mention whether it's possible to challenge in the court of cassation instance the decision of the court of the appellate instance based on the consequences of the review of the motion of the court of the first instance. In this situation, if the appellate court does not secure the claim, the question arises, the cassation instance court cannot review the complaints on the court decisions of the appellate instance court to secure the claim or to leave the motion of the first court without change on the security of the claim, or the appellate court decision to refuse the security of the claim or to change or not to change the decision of the first instance court decision. Then the Great Chamber decided that in order to remove negative consequences for the party, the cassation court should always be able to challenge the measures to secure the claim that were taken. In the situation if security measures were not taken to ensure the claim by the first instance court and the appellate court did not change anything, or the appellate court did not apply these measures, then the court decisions on refusal to make measures to secure the claim or the court decisions on keeping the decision without changes when there is refusal to secure the claim, these decisions cannot be contested in the Supreme Court. This limitation in access to cassation review do not deprive the participants on the case who receive the refusal to secure the claim to have a repetitive claim for the security in the first instance court or in the appellate court when the case is in their review. Another aspect of Article 6 is the legal certainty. The legal certainty as present in the proceeding of the Great Chamber, there is the case on in what way we have to process the refusal in opening of the appellate proceeding. Should this refusal be in one person or should it be collective? The case is not reviewed yet, but it was transferred by the Cassation Civil Courts as part of the Supreme Court for removal from the conclusion of the Cassation Administrative Court that the refusal in opening the appellate proceeding is accepted only by the collective body, by 3 judges. And the Cassation Civil Court believes that this refusal can and should be done in one person. Case is not reviewed, but obviously it raises the issue of application of Article 6 of the Convention in terms of legal certainty and the correctness of application of the procedure provisions of the process. If you're interested, please observe this problem. I'd like to describe another problematic situation regarding the case when we are able to talk about limitation of possibility of the court to review the case in the jurisdiction to which this case was classified by the Cassation Instance Court. At your screen, there is code of the Lviv case, in which there is paradoxical situation. During the time when the case was reviewed, the procedural law changed, and the category of cases which in the past were reviewed according to the rules of civil judiciary, civil law, it was decided by the Great Chamber that this category of cases have to be reviewed by the rules of administrative justice. But the problem is the following. The court of the first instance which opened the proceeding on the case, and then the same court of the first instance to which the case went for the second review after the cassation from the highest specialized court of Ukraine on the review of civil and criminal cases. That court reviewed the case according to the rules of civil justice because there was indication for that by the high specialized court, that is the jurisdiction of this dispute by the Cassation Court was already identified, while the case went for the second time to the Cassation Instance Court. There was the position of the Great Chamber of the Supreme Court that this case cannot be reviewed according to the rules of the civil justice. As there was the problem, what has the priority, what has the precedence, the provision of the law that we need to take into account the opinion on the application of the appropriate provisions of the procedural law, which are written in the decrees of the Great Chamber of the Supreme Court or for lower instances courts, what is compulsory is indications of the Cassation Court, which they received when the case went for the second review. In this case, the Great Chamber of the Supreme Court mentioned that what is compulsory are the conclusions made by the Great Chamber of the Supreme Court. So the fact that the appellate instance court already knew about the new approach of the Great Chamber of the Supreme Court obliged it to close the proceeding on the case and not to follow the previous indications of the high specialized court. This approach was agreed not by all the judges, and part of the judges of the Great Chamber believed that if there is collision between the instructions on the need to take into account by the courts the conclusions on the application of the provisions of the law, which are written in the explanations of the Supreme Court, and there is compulsory indications of the cassation court's instructions in this specific case, then the court had to be guided by the indications of the court of the cassation instance, which it gave when they sent the case for the new review. I'd like to draw your attention to the last point, which is the right for the review of the case by the court, which is established by the law. Once again, this is the aspect related to the application of Article 6 of the Convention. And the most often, the Great Chamber of the Supreme Court, I don't understand why, but they deal with applications, complaints, which are filed as to the court of the fourth instance to review the court decisions. First of all, to review the court decision, which is approved by the cassation civil court, by the cassation administrative court, by the cassation commercial court, or by the cassation criminal court. As a matter of fact, during all the years, in particular this year, as you can see, very often we have to deal with the cases, with the applications to the Great Chamber, just like to the fourth instance court, which it is not, but the practice is the same one in the situations. The cassation review already took place, and the second cassation in the Great Chamber of the Supreme Court is not possible. Thank you very much for your attention. Thank you, Mr. Dmitrov, for your presentation. We have a number of questions, but as our time is limited, only one question will be asked. Does the Supreme Court qualify the lockdown and coronavirus circumstances as good circumstances to miss the procedural terms? Dmitrov, please, very quickly. Yes, thank you for your question. First, during the strict lockdown, for sure, until some date in summer, we qualified the quarantine limitations as the ones within which all the terms are extended. It was clearly envisaged in the legislation. However, I'd like to draw your attention that starting with autumn this year, the applicants still continue to use the lockdown as the grounds for all the cases to extend the terms, not providing any evidence that it was missed for good reasons. I'm not ready to give the cause of all cases or some cases, some decisions on this matter by the Great Chamber of the Supreme Court. Just recently, as I remember, one of the latest one was dedicated to this problem. In the Administrative Jurisdiction Court, we resolved this issue when the individual argues that they are in the risk group, that they are afraid to go outside, that now they live not in their place of registration, so they cannot fulfill the requirements in the decision of the court to leave this motion without movement, and they asked to extend the execution of this motion for the time of lockdown of the request to extend the term because they cannot leave the house because they are afraid of getting sick. In this situation, when there are no documents which are filed on the fact that there are some risks for this individual, no evidence was provided on the statements of the person that they were sick, that they had temporary loss of workability, that they moved from their permanent place of residence, they did not reside in the place of their registration. In this case, the Great Chamber of the Supreme Court does not accept this referral to the lockdown limitations. We believe that the argument to extend the terms has no good grounds. Thank you, Dmitry. I see more questions, but unfortunately we have to move forward because we're behind our schedule. I will read the questions later, and I'd like to give the floor to our next speaker, the head of Department of Theory, Philosophy of the Law at Lviv National University, Mr. Vitaly Kosovich. The topic of the presentation is evaluation notions in the Convention on the Protection of Human Rights and Basic Freedoms, the urgent matters of application on the example of Article 6. Please, Mr. Vitaly. Thank you very much, Ms. Natalia. Dear colleagues, good afternoon, everyone. First, I would like to thank you for this opportunity to make a presentation at this forum. And also, I'd like to thank Taras Pashuk, who works at the staff of the European Court for Human Rights, and he helps me with the case law of the European Court for Human Rights. I'd like to start my presentation with the following. Today, the Convention and the case law of ECHR has become the part of our judiciary practice. In methodological recommendations on legal drafting technique, It is said that legislation has to be drafted with taking into account the convention and practice of the European Court. The procedural codes, as well known, interpret the rule of law once again as in the context of conventional norms and practices of the ECHR. So today, this is our reality that we have to consider. At the same time, I would like to draw your attention to some problems or debatable matters which are related to implementation of the conventional provisions and practices of ECHR and to our enforcement practice. And these difficulties are related to the presence in the European Convention of the evaluation norms and evaluation provisions. I'd like to remind the colleagues some scientific interpretation, what is understood under the evaluation provisions or evaluation notions. These are reflections of abstract characteristics of social significance of real or potential facts, which has to be specified during application or implementation of these provisions with the notions which ensure individual legal regulation. Having learned the text of the convention, we can identify 85 evaluation notions. In the first chapter, there are 57, in the second, there are 24, and in the third, there are 4. No doubt, the leader in this sense is Article 6 of the Convention, the right for fair trial, which has 16 of these notions. These are the notions of fair trial, fair review, reasonable term, independent court, impartial court, the interests of moral, the interests of public order, the interests of national security and democratic society, severe need, special circumstances, interests of justice, urgent, informed, and detailed information, necessary time, necessary ability, sufficient funds. Analyzing these notions, we can come to the conclusion that they concern some categories of legal relations. Maybe they're related.
And perhaps they do not affect human rights in general, but rather the entire framework of values and modern state, rule-governed state. The feasibility of or exigency of the use of such standards is a problem, and the function of such standards should ensure individual legal regulation and division of function, just mitigating the formal functions, overcoming some problems in the legislation, and ensure the necessary legal certainty, prognostic function, and at the same time, such value standards add universality to the convention norms and provisions. They, at the same time, establish certain moments open to discussion and problems with their application, as the analysis of the ECTHR judgment shows. That also pertains to the national courts in Ukraine. What are these difficulties? First of all, these value concepts establish a broad margin of appreciation and some subjectivity when certain specific cases are adjudicated. And we can illustrate it with the position of the European Court with the notion of fairness and justice in the part of right to legal assistance from the very first examination. It's yeah, I can refer you to the case versus Turkey. So at the same time, the analysis of the cases shows that the formal application of this principle might lead to some controversial conclusions. So the impact on the sphere of the application of the notions of the fair trial and access to legal assistance during the investigation is reflected in the case against the UK. In particular, the conditions when the right to fair trial is not violated because there was no legal assistance during the first examination. And a certain negative impact is that such value concepts are an objective barrier to the unifying of case law of the European Court. And thus, the judgments are not applied equally and uniformly by the national courts. And sometimes there is abuse of these judgments by the national courts. Just looking at the decisions of the cassation courts within the Supreme Courts and review by the Grand Chamber because of the exclusive legal problem or question of law, we can see certain cases with a very immaterial link between the judgments of the ECTHR and judgments of the or decisions of the national court. And that creates ideal conditions for certain too creative an interpretation by national courts. Value concepts might entail mistakes in applying the convention norms by the national courts, and an example can be case Eremenko and Shebelnikov versus Ukraine. The ECTHR established the violation of the right to a fair trial, but the national courts revised their decisions, but then another problem arose when the European Court established a violation of Article 6. These three moments were related to separate characteristics of the value concepts. But their application is related to what is the object of evaluation when the convention norms and standards are applied. The object of the evaluation by the ECTHR is a whole set of essential factors that are essential for the case and for the individuals. So, and for the consideration of the court and decisions and judgment established, because the value of this category can be perceived differently by different individuals. And by applying such norms, the European Court looks at the contents with the due regard to the moral, to the values of the society, etc. And we can refer here to an example of the case Preliv and others versus the UK. The court developed the notion of fair trial and access to the legal assistance at the very early stages of the proceedings and conditions where such right can be limited. And the court, in a certain way, analyzed the need to limit access to legal assistance without value criteria. The court established that where the government convincingly demonstrated the existence of the dire need and the such as the implications for life, freedom, and rights of other persons, this can be the reason for the limitation of access to legal assistance for the purposes of Article 6 of the Convention. Because under such circumstances, the state has to protect the rights of actual or potential victims under Article 6 of the Convention. Analyzing cases of the European Court related to the use of such norms, I can notice the carefulness with the interpretation of such value concepts by the court in order to avoid excessive subjectivity. Thus, a court uses comparative legal analysis. The analysis of the ECTHR judgments related to the application of the convention provision shows that in every individual case, the court takes a very individualized, very specific judgment. And under the circumstances, there is a need to look for certain guarantees for the proper enforcement activity of judges at the national and international level. And we can come up with two blocks of certain recommendations in the context of interpreting and implying value concepts of the convention. Let us start with the interpretation rules. Such rules include, first, the explanation of the contents of certain value concepts in different provisions of the convention. Then socially valuable components of such concepts should be proposed by the interpreter with the in-depth analysis of knowledge about them and with the case law of the European Court. The interpretation of these concepts should be commensurable with their perception by the European community. Of course, the norms evolve and the convention is a living instrument, but we understand that the interpretation of value concept also develops. And the interpretation of a value concept should also rely on the use of formally defined terms. I will give you an example whereby the European Court interprets certain things with value concept. What can be proposed in terms of how these concepts should be used? The decisions of the subjects, including the European Court, cannot rely only on value concepts. And here, I can refer to the very careful examination of the circumstances of the case. Now, the situation about the social nature of certain phenomena covered by value concepts should be additionally examined and confirmed by the court. The motivation of the opinion of the court, we should not only refer to certain circumstances of the case, but also the availability of certain socially essential or socially significant characteristics. And the decision can be taken only with the due regard to the prejudicial importance of a certain act covered by the value concept. Another aspect that I would like to draw your attention to, that's lack of uniformity in the application of the value concept of the convention, which is caused by the national case law. And this can serve as a guarantee of avoidance of ununiform application of those judgments by national courts. Courts should state not only the similarity of certain circumstances in the case based on the results of which a certain legal documents is issued, and cases where the ECTHR judgment set up a precedent or just a certain standard, but also guarantee their similar social significance in terms of value concept. Here I should refer to the positions of the academics and practitioners with regard to the notion of a reasonable time. Besides, the Act should also have the explanation of the legal assessment that is given based on the ECTHR judgment with due regard of individual specifics of every case. We believe that in this respect, it would be important to, if the Grand Chamber could issue certain pilot judgments with the illustration of how to operate with the value concept and how you should refer to the ECTHR judgments based on value concepts. Because in this very concept, in our country, national court judgments or decisions are not uniform. And I would also like to say that value concepts, of course, ensure uniformity and universality of the convention provisions and case law of the European Court for Human Rights, but national judicial practices in general. So the considerations that I've vented and the considerations that exist at the level of the doctrine should support the adequacy of this application. And to end, I would like to say that I planned to refer to a number of other ECTHR judgments that actually illustrate my premises, but I hope that we will publish an article that will be accessible to all. Thank you very much, Mr. Kosovic. There is a question to you, whether the Constitution of Ukraine should guarantee not only the right to court protection, but also the right to a fair trial and access to justice. Thank you, Natalia. I think it can, of course, but we know that the entire procedure of amending the Constitution is too complex. Value concepts are universal and they ensure the universality of the protection of human rights. And I think that the fact that the global community, the European community based on the ECTHR recognize does not need confirmation in the Constitution. Thank you very much. I would like to thank all speakers of the first panel. We have actually exhausted our time and we are behind our schedule. So I encourage you to have 5 minutes break and then we will reconvene. Thank you very much. Сережа, вы здесь еще? Сережа? Сергей. Здесь. Что мы будем тут делать? Ну, у них перерыв на 5 минут. Я не доработала 5 минут. Мы продолжаем, я начинаю или вы уже начинаете? Как вы скажете? Да? Прощаете 5 минут мне? Ужас. Я ж не отстираю. Можете потом начать раньше, я не знаю. Хотя уже там обед будет, да, уже в час. Так они не прервутся вовремя, потому что, опять же, видите, у них нет времени. Ну, давайте я включусь через 15 тогда. Окей, хорошо, договорились.
Доброго дня, шановні учасники форуму. Ми переходимо до нашої другої сесії Львівської.
Good afternoon, dear participants. We move to our second session on establishing effective cooperation with the Supreme Court. Before I introduce our first speaker, I'd like to briefly say that for the Council of Europe and for the project which I represent today, which provides further support to Ukraine in execution of the decisions of the ECHR, for us, one of the priorities is to provide necessary assistance to the Supreme Court to build efficient, direct cooperation with the European Court of Human Rights. To achieve this objective, we suggest to start to apply the consultative opinions, which is envisaged by Protocol 16 to the European Convention on Human Rights. This protocol provides the ability of direct dialogue with the European Court for Human Rights, and also it allows to solve different court cases given the instructions of the European Court of Human Rights. When the protocol was adopted, the members of the Council of Europe had three main objectives. First, they tried to strengthen the observation of human rights and freedom guaranteed by the European Convention on Human Rights, and to expedite the resolution of the similar cases at national level. We also hope that application of this consultative opinions will decrease the number of applications to the CHR, because unfortunately over the last 2 years Ukraine is in top places among the countries on which we have the greatest number of applications to the CHR. It is the rating which we would like not to see for Ukraine, and we'll be trying to make all efforts to change this. Ultimately, everyone envisages that this option is targeted at strengthening the trust of the society to the judiciary, and given the court reform that are underway, this is one of the key objectives of the reform. Although the Protocol 16, supported by the Council of Europe, it was ratified in 2017. In 2018, it entered into force as of today, as of the end of 2020. Unfortunately, still, there are no results. We invite our speakers to give the answers to some questions which are causing discussions today that prevents the adoption of the appropriate legislation which would allow to directly apply this option. I invite our first speaker, Mr. Andrei Medved, who is the Associate Professor of Lviv Trade and Economics University, to give the presentation on the right of consultative opinion according to the Protocol 16 of the European Convention on Human Rights in the context of the right for fair trial. Dear participants, I remind you that 15 minutes is provided for presentation and 5 to 7 minutes for questions and answers. So please continue good tradition and write your questions in the chat. I will read them out. Thank you. Mr. Andrei, if you can hear us, please. Good afternoon. I hope that you can hear and see me well. First, I would like to thank the organizers for this opportunity to participate in the forum. I'd like to thank the organizers and co-organizers and coordinators. In this aspect, the Lviv Forum is one of the events which define the number of activities within Ukraine on human rights protection and the concept of the case law of the European Court for Human Rights. So I would like to present my report, which has the title of Rights for Consultative Opinion according to the Protocol 16 in the context of the right for fair trial. Now I would like to try to upload my presentation. Just a second. I hope that we will not have technical problems. just like it was mentioned before, Protocol 16 became effective in 2016. It was ratified. In 2018, it was ratified by 15 countries. You can see them on the screen. In particular, it was ratified by Ukraine. As of now, the protocol was signed by 7 countries. So we have the chance to assume that in the nearest future, the number of ratifications of the protocol can grow significantly. Overall, Protocol 16 is dedicated to one of the issues, how it was characterized by the former president of the European Court, by Mr. Spillman. It is the protocol of dialogue, which implements new consultative function of the European Court, targeted at supporting the efforts of national courts by means of change their status to partners of the court. The preamble to the Protocol 16 outlines that the motives of developments and emphasizes that extension of powers of OSCE on providing consultative opinions will strengthen interaction between the court and national judiciary authorities, and it will reinforce the implementation of the convention according to the principle of subsidiarity. Article 1st establishes the right of supreme judicial authority, so the participating states, within some cases, they review to apply with justified requests to the ECHR for consultative opinions on principal matters related to interpretations or application of rights and freedoms guaranteed by the Convention and protocols to the Convention. I have to note that feasibility of implementation of this procedure was expressed in the reports of group according to the plan of action approved in 2005 at the third summit of the heads of states of governments of the Council of Europe. It was mentioned that getting by the supreme judiciary authorities the consultative functions of the European Court will not only improve the dialogue of the European Court with national courts, but also it will strengthen the so-called constitutional role of the ECHR. Also, the need for these measures was dictated by the threat of possible differences in interpretation and application of the rights guaranteed by the Convention, by the ECHR and Supreme National Courts. This situation appeared from time to time, which was mentioned by the European Court, for example, in the case Condor and Dublin versus Ireland of 1992. The initiative of the group of sages to develop the Protocol of 16 found its reflection in Izmir Declaration of 2011 and Brighton Declaration of 2012. They clearly mentioned the need to improve the interaction between the ECHR and the national authorities. We have to remember that the law of European right of European Court to provide consultative opinions is not absolute novelty of the Protocol 16. Although this right was not guaranteed by the Convention in its version of 1950, but additional Protocol 2nd envisages the rights of European Court based on request of the Council of Ministers to provide consultative opinions on the legal matters. However, the subject of these opinions could be only interpretation of the Convention and protocols to it, with exception of content, volume of rights and freedoms identified in Chapter 1 of the Convention, and also protocols to it, and also any other matter which is raised by the Commission, Court, or the Committee of the Ministers as a consequence of any proceeding. These powers of the European courts, almost word for word, were reflected in Article 1 of the Protocol 11 of 1994, which made changes to the Protocol 2. At this time, this is reflected in Article 47 and 48 and 49 of the Convention. It is interesting that the practice of provision by the European Court of these opinions is not very widespread, especially the Committee of Ministers only 3 times referred to the European Court the requests to provide consultative opinions. For the first time it was in 2002, and then the European Court made the conclusion that it has no powers to give answer to this request due to possible review of similar matters. In 2008, for the second request of the Committee of Ministers, the European Court provided the interpretation of provisions of Articles 21st and 22nd of the Convention. As a consequence, the gender professional requirements to the candidates to the positions of judges of the European Court were removed. The third request on consultative opinion from the Committee of Ministers in 2009, the reason was the revoking by Ukraine the list of candidates for election to the position of judges of the European Court filed in 2007 and replacement of candidates of this list. The consultative opinion, which was given in 2010 by the ECHR, among others, provided the interpretation of the contents and procedure of implementation of the rights of participating states to revoke and to change the list they filed as candidates for the positions of judges of the court, which allowed the opportunity to select the judge of the European Court from Ukraine. At the same time, the main differences of the consultative competency of the ECHR regulated by Article 47 of the Convention on Implementation of and implemented by Protocol 16 are the list of entities which have the right to file applications for getting consultative opinion and circle of issues on which these opinions may be provided. These two aspects, alongside with legal power of consultative opinions of the ECHR, were identified as three key parameters of the new procedure and explanation reports. So Protocol 16 from the Council of Europe dated in 2013. In Protocol 16, the maximal dispositional outline of the circle of entities which may have the right for the request to the ECHR. And the high judicial authorities or Supreme Courts or tribunals. As the explanation report says, this formulation is called to avoid possible complications, allowing for some freedom of choice and envisaging the ability to include into this course in tribunals, which may be below constitutional or Supreme Court, but still they have some special significance as they are highest for some category of cases. The requirements have to be fulfilled on exhausting all national remedies of legal protection, and in combination with Article 10 of the Protocol number 16, the rights of the participating state to independently determine the judicial authorities and to change their lists at any time. This formulation provides the proper flexibility and taking into account specificities of national judiciary systems. Given these requirements, it is justified to have the principles of the law of Ukraine on ratification of Protocol 15 and 16 to the Convention on provision of these powers to the Supreme Court, which is the highest court in the judiciary system of Ukraine. It ensures the sustainability and unity of the court practice. Also, these rights hypothetically may be given to high specialized courts, which are the High Court on Intellectual Property and High Anti-Corruption Court. What is interesting and quite debatable is the matter of inclusion into the list of these courts of the Constitutional Court of Ukraine, because although Constitutional Court, when expressing its legal positions quite often in the decisions, which refers to the practice of European Court, but given the scope of powers which are determined by the Constitution and law of Ukraine on Constitutional Court, establishing the legal status of Constitutional Court as the body of constitutional jurisdiction, which has to ensure the rule of Constitution of Ukraine. Some experts
and some justices of the Constitutional Court point to the fact that taking on board the opinions of ECHR could actually show that such judgments and such opinions do have impact on the legal system in Ukraine. Another key parameter established in Protocol 16, as I said, is the scope of matters on which ECTHR would provide advisory opinion. These are key issues pertaining to the interpretation and understanding of the rights and freedoms defined in the Constitution. And it is different from the matters of opinions provided by the Committee of Ministers. At the same time, they cover the general jurisdiction of the European Court established by Article 32 of the Convention. However, it is close in meaning to established by Article 43 of the Convention grounds for referring cases to the Grand Chamber on the motion of one of the parties once the decision is or judgment is pronounced, that are referred to as essential matters on the interpretation or application of convention or protocols thereto, or general significance matters or matters of general significance. It is not an additional matter because according to the explanatory report to Protocol 16, the provisions of Article 1 of this protocol were formulated in view of the provisions of the convention. And it is not limited only to the bodies entitled to pronounce such opinions, that is the Grand Chamber of ECTHR, because the subjects of the opinions are very close to one of the reasons where the chamber can dismiss this request according to Article 30 of the convention. So when a case raises essential matters of interpretation of the convention and the protocols thereto. And now the Grand Chamber usually issues 2 to 10 resolutions where the extended interpretation of sometimes contentious or difficult matters of the convention. So now that the Grand Chamber can provide advisory opinion on principal matters of interpretation and application of the convention and protocols thereto, it would be logical to find the correlation and continuation of the powers of the Grand Chamber as the implementation of its case law. Now, the implementation of the provisions of Protocol 16 sets up benchmarks for the national courts that should apply the convention at the national level. That's why Article 1 of Protocol 16 establishes certain criteria according to which the national courts can seek advisory opinion from the ECTHR, not on abstract matters, but in the context of a case pending before it. The National Court should also reason for its request and provide the relevant legal and factual background of the pending case. In light of this, we will say that Article 6 of the Convention on the Right to a Fair Trial takes a key position in the entire framework of the values of democratic societies, and it is one of the most complex in the convention in terms of the scope of its application and the number of questions that can arise as a result, and the number of explanations and interpretations provided by ECTHR, as we could see from the earlier presentations. It is also corroborated by the data of the official statistics over the course of the activities of the ECTHRs. The greatest number of violations in cases considered by the ECTHR concerned Article 6 And as Danishevska says at the very beginning, it made up 40% of the overall number of judgments against Ukraine. Looking at the statistics of the ECTHR judgments, it is impressive. Out of the total number of judgments in cases against Ukraine, and there were 1,413 accepted by, or admitted by the ECTHR in 1959 to 2019. Violations of Article 6, that is, right to a fair trial, were established in 429 cases, and as to the failure to execute the rights in 137 judgments. So the principle matters of the interpretation and application of the right to a fair trial with a high likelihood will be the matter of advisory opinions of the Grand Chamber of the ECTHR. At the same time, one should know that the portal of ECTHR has got two advisory opinions, one issued in April 2019 on request of the Cassation Court of France on the application of Article 8 of the Convention. That's the right to respect of private and family life in the context of the right of the adoptive mother to be deemed legitimate mother of a child. And another advisory opinion was issued in August 2019 with regard to the inquiry by the Constitutional Court of Armenia on the interpretation of the Criminal Code of Ukraine on the coup d'etat and its application in the context of, or in conjunction with, Article 7 of the Convention in respect of the former president of that country. So this opinion was announced in May 2020. So the National Supreme Court has developed certain case law on applying the advisory opinions in their own decisions. So particularly in the Cassation Administrative Court, and you can see the statistics there. And the Supreme Court dismissed certain motions of the parties seeking advisory opinion from the European Court of Human Rights. And the Supreme Court argued that during the consideration of the case, no principal issues regarding the interpretation or applications of the Convention provisions, including Article 6, arose. At the same time, it is emphasized that the motion by the litigants did not provide convincing argument why they need certain advisory opinions from the European Court of Human Rights. So I think that the Supreme Court is prone to placing onerous of proof for the inquiry or the seeking as advisory opinion on the parties, and this need should be vented when the case is considered by the trial and appellate courts. Some experts will argue that this position of the Supreme Court changes the essence and the content of Protocol 16, because the Supreme Court, as the representative of the state, should make sure that all of the provisions of the Convention have been observed and provide examples of the position of the European Court on those violations. I should also emphasize that perhaps mechanisms of seeking advisory opinion by the parties to the cases might sometimes be used as a pretext to prolong the proceedings and to delay the decision. That's why the report to this protocol provides for the opportunity for the national courts to send such inquiries for advisory opinions in the national languages, and preparedness of the European Court to cooperate with the national bodies in order to have advisory opinions translated quickly, and which is a positive aspect of the entire procedure. That facilitates the clearer understanding of the advisory opinion and its accessibility to a broader range of stakeholders, but also timely obtaining of advisory opinions by the national courts. Thus, without having to prolong the procedures in the pending cases. And the Protocol 16 provides for the establishment of the so-called high priority at every stage of the procedure in providing or issuing advisory opinions as compared to other procedures. And it is emphasized that there is a need to avoid any unjustified delays in consideration of this matter. So the issuance of advisory opinions is usually timed 6 to 10 months. And we believe that they are quite acceptable as terms for issuing such opinions. And the third parameter of the specificity of issuing advisory opinions was the lack of their binding nature or their non-binding nature, unlike that of the ECTHR judgments. So one can actually challenge the usefulness of advisory opinion mechanism in general, because the national courts do not have to always follow the interpretation of the ECTHR. So a certain case can be the subject matter of its consideration if the interested party submits an individual complaint. So a lot will depend on the internal domestic activities of the national courts when they receive advisory opinion. But I would not say that such arguments are quite logical and well-grounded. And I again refer you to the explanatory note to Protocol 16. Indeed, national bodies that seek and receive advisory opinion are free to decide how to apply them in their own practices and case law. And the fact that the ECTHR issued the advisory opinion on the issues raised in the context of certain cases pending in the national courts would not prevent its parties to later implement their or exercise their right to apply to the ECTHR. At the same time, if the application is filed after the time frame established in the advisory opinion, it can be expected that the part of the application pertaining to the matters considered in the advisory opinion would be deemed inadmissible. So the national court that voluntarily sought advisory opinion from ECTHR will take on board the opinion of that court, particularly given that it will both improve the credibility of the court decision, and the parties will get more assurances of the fairness of the decision by the national court. So, and even though advisory opinions of the ECTHR issued in accordance with Protocol 16 are not binding, they still can be treated as part of the case law of the European Court for Human Rights. And to end, I would say that the interpretation and application of the convention and protocol provisions should be a common practice to the national courts and become part of the ECTHR case law. Once Protocol 16 takes effect, the new advisory function of the ECTHR is implemented based on the principle of subsidiarity that should eventually reduce the number of applications filed to the court. It will allow the national courts and the ECTHR to find common ground in a number of matters, including the right to a fair trial. But the efficiency of this new procedure will depend on the activities of the national courts and will be felt in a longer time perspective. And to end, I would like to say that because of the lack of time, I haven't had an opportunity to go into detail on how the national courts have been taken advisory opinions on board since 2017. I studied this issue in great detail and I published a monography and I encourage those who are interested in these matters to peruse it. Thank you very much. Thank you, Andriy, for this in-depth presentation. We've got a question from Mr. Nazarius Tetsuk. It's like this. How can you explain the difference in the efficiency of the operation of this institute within the Council of Europe and the European Union? Because we know that these prejudicial inquiries are quite popular. Can you answer this question? I think the matter is that neither the practice of obtaining advisory opinion from the ECTHR by the EU member states or by the Council of Europe member states over the last 2 years, since Protocol 16 took effect, is not very well developed. And the matter, the reason to my mind is that the ECTHR case law and in specific cases is so well developed and so detailed that the national courts have no need in additional interpretation and explanation on certain matters. So once this legal mechanism evolves, we will see that it is applied more often. But now almost every provision of the European Convention and protocols thereto have been interpreted in great detail, in sufficient detail in the ECTHR case law. Thank you very much. Before I give the floor to our next report, I would tell you that within our Council of Europe project, we provide assistance to many authorities in Ukrainian judicial system in order to have Protocol 16 implemented. 2 bills were drafted. 2 of them got a positive opinion from the Council of Europe, but for some reasons, none of them was adopted by Parliament. And MP Babi from the Committee on the Execution of the ECTHR judgment within the Ukrainian Parliament sought our expertise in analyzing those bills that provide for the implementation of Protocol 16 in Ukraine. So I will give the floor to the expert of our project who conducted this analysis, and we actually presented it to MPs and to justices of the Supreme Court in order to answer the question how the registered bill addresses the contentious issues and whether it is in line with the protocol provisions and with the procedural legislation of Ukraine, and actually point out to its upsides and downsides. Can you hear me, Ms. Kucheruk? Yes, I can. I hope you can hear me too.
Доброго дня, шановні учасники форуму.
Good afternoon, dear participants of the forum. I am Nina Kucheruk, national expert, one of the projects of Council of Europe. Today, at this forum, we will discuss the urgent matters of implementation of Protocol 16 to the national legislation, in particular the gaps in this area and potential further changes which have to be introduced into the legislation. I'd like to start with ongoing statistics published at the website of European Court for Human Rights on the number of applications pending the review of this court. As we know, Ukraine for many years is the leader on the number of complaints filed to the European Court for Human Rights. For example, as of the end of 2019, Ukraine was number 3 with more than 8,000 applications pending review of ECHR, after Turkey and Russia. However, in 2020, as of September 30, 2020, Ukraine went ahead in the center rating, went ahead of Turkey, and now it occupies second position with a number of more than 10,000 applications. And in review at the European Court, it is second after Russia. This sad statistics. One of the ways of the overcoming of this statistics could be quality and efficient functioning of the option of consultative opinion, which is discussed in Protocol 16 to the European Convention. As it was mentioned by the previous speaker, all know that Protocol 16 envisages the option for the Supreme Judicial authorities to apply to the CHR to get consultative opinion on the principal matters of application or interpretation of the rights and freedoms guaranteed by the European Convention. Ukraine made a significant step on this way in October 2017. It ratified Protocol 16. However, it became effective on September 1st, 2018. There were no changes to procedural law. As it was mentioned by Ms. Marta, at the Parliament of Ukraine, the draft law 3120 was registered in the Parliament. It regulates many important matters despite its limited volume. In my presentation, I'd like to discuss main advantages and disadvantages of this draft in regulating the implementation of Protocol 16. One of the important matters which is regulated by the draft is identification of subjects of application. When adopting the law on ratification, the Ukraine identified the Supreme Court as this entity, but further legislation does not specify what should be the entity within the Supreme Court, because all know that the Supreme Court has a Great Chamber and 4 cassation courts. Draft Law 3120 suggests that only Great Chamber may apply to the Supreme Court on these matters. This approach has advantages and disadvantages. Advantages include more thorough and justified resolution of issue for the need to apply to European Court, because this matter first is resolved at cassation courts, and in case of grounds within this legal matter, they will transfer the case to the Great Chamber. The Great Chamber will examine this matter once again. 2 entities will be solving the matter whether they should apply to the European Court. Also, there is more thorough study of this issue, which is ensured by the quality and quantity of the composition of the Great Chamber, because it includes 21 judges. Another advantage for the European Court of Human Rights is a reduction of the workload of the European Court by the number of potential requests to get the consultative opinion. The less entities could apply, the less applications we have, and the less consultative opinions we have. If we talk about positive developments, the advantages, also we have some disadvantages. If we have less applications to the European Court, we will get less consultative opinions, and this does not promote the reduction of number of complaints to the European Court. However, this position of giving the right to apply to the ECHR only to the Grey Chamber has its disadvantages. The first one is the workloads for the Grey Chamber. When the powers are given to this chamber, it will increase the workload because the Grey Chamber will have to examine the circumstances of the case to solve the issue of applying or not applying to ECHR, to prepare the motivated requests, and so on. In turn, it may have negative impacts on the review of cases. In particular, it will lead to superficial review of matters of application to ECHR and appropriate cases in general. As a consequence, it may lead also to increase of terms of review of the cases, so-called double examination of case, first by the Cassation Court and then by the Grey Chamber, will take some period of time, which may have negative impact on the reasonability of terms of reviewing the case. It would be feasible to give this right not only to the Grey Chamber, but also to Cassation Courts, this right to apply to CHR for consultative opinion. This approach of giving Cassation Courts the right to apply to CHR fully complies with existing legislation, because during notification, Ukraine identified that Cassation Courts could also apply as their part to the Supreme Court. Second, it will decrease the workload of the Grey Chamber if Cassation Courts can directly apply to CHR. Also, it reduces the time because the case will not be transferred to Grey Chamber. The Grey Chamber will not start the case file. It will reduce the amount of time. It will promote reasonable terms of reviewing the case. Also, in my view, this will promote a reduction of number of consultative opinions if every Cassation Court will have these powers. From the first perspective, it may seem that if we give the powers to Cassation Courts as part of the panel of judges to apply to the CHR, and then in this case, it is the disadvantage because these measures will be reviewed only by a limited number of judges, not by 21 judges like in the Grey Chamber. But I believe this is not the disadvantage because every judge, moreover the Supreme Court judge, according to the law and judiciary and status of judges, they're professional and competent, and these matters can be given to the Cassation Courts not as part of the unified chamber, but as part of the panel of judges. While solving the issues of applying to the CHR for consultative opinion, it's important to adhere to the conditions of application. Draft 3120 in this part is compliant to the standards of COE and recommendation of ACHR. On application of Protocol 16, it determines two main reasons of application: the need to solve the principles maths of interpretation or application of conventional right of freedom. And second, the case, in this case, we need to solve the matter in this case is on the review of the Grey Chamber. Unfortunately, draft 3120 doesn't pay attention to what should be understood under the principal matter. The European Court for Human Rights determines three main types of this principal matters. First of all, these are situations in which the case which is on review of the Supreme Court, it touches on new matter on European Convention. Second case is when the circumstance of the case makes it impossible to apply at the same time the practice of the European Court. And third, the presence of the practice of European Court, which is contradictory. In our view, it is feasible also to determine these general types of principal matters at the level of law and procedural law. We believe it will facilitate the proceedings of the Supreme Court, the Grey Chamber, because it may look at these types of principal matters. This list of matters is not exhaustive. It may be also mentioned at the legal level. Moreover, enshrining these provisions in the law will promote effective interaction and quicker solving of the matters on getting the consultative opinion if this request complies with the requirements, in particular on the correct definition of the principal matters. Another important issue is determining the stage at which the Supreme Court may apply for getting the consultative opinion from the CHR. According to the draft, this has to be done before making the decision on the case. That is, before the Supreme Court makes the decision on the case. Another important point which is emphasized by CHR, but which is not suggested by the draft 3120, is establishing all necessary circumstances of the case. If Supreme Court sees that some circumstances of the case which have decisive significance, the case should be transferred for new review, and we should not send the request for consultative opinion. If we compile consultative opinion, there will be the matter form and content. The draft law 3120 once again does not regulate this at all. However, there are details on this which are determined by the European Court in their methodological recommendations. In particular, in terms of content, the European Court recommends to identify the reasons, the causes of filing this request, the essence of the matter, the legal aspects, the provisions of national legislation, and articles of the convention which are discussed, and regarding which there is the application and the request is made to the European Court on these articles. Also, there may be additional matters identified if it is feasible in the opinion of the Supreme Court. In particular, this is the essence, the description of essence of arguments in the national proceeding as the position of the Supreme Court in this request. Obviously, the exhaustive list should not be identified in national law, but to facilitate the work for the Supreme Court and to simplify the work to process the request, it is feasible to identify those general requirements to the content of the request. Once again, this list should not be exhaustive. Also, European Court of Human Rights, in their recommendations, dedicate significant importance to the form, to the font, to the format, to the paper, to the numbers, and so on. In our legislation, in our procedural law, we don't take these legal provisions into account to determine the requirements to fonts, to number of pages, but we believe it is possible to have these requirements at the level of the guideline for the workflow of the specific court. The important matter, which unfortunately remains outside, beyond the legislation at this point of time, and it is not mentioned in the draft law 3120, it is the issue of translation. According to national law, according to the position of the European Court, the requests for getting consultative opinion may be filed in Ukrainian. However, in the term identified by a European Court, this request should be translated into English or French. However, current law doesn't determine who should perform this translation. Moreover, the law and the draft do not regulate the matter who performs the translation of consultative opinions provided by the European Court. In our view, this matter may be regulated by given the duty of translation of the request and cover letter by the party which initiates the application to the European Court. If this matter is initiated by the Supreme Court, then it should be done by the individual which contests the court decision to the highest court, to the Supreme Court. Or the second option, if we talk about official translation, and especially when we talk about translation of consultative opinions, this is the definition of the specific public agency which should be responsible for performing this official translation. The important matter is the priority. Unfortunately, once again, draft 3120 doesn't envisage the regulation of this matter. However, given that this matter is quite important, especially in criminal cases, it is feasible to envisage this. In particular, CHR suggests to empower highest judiciary bodies of the state, where the authorities, where the competence is to inform the European Court on the circumstances which demonstrate the need for priority resolution to review the request for the consultative opinion. This justification has to be motivated. They have to be written in the cover letter to the request, and at every page of the request, it is feasible to mention that it is urgent and it is according to the Protocol 16. As it was mentioned, the matter of priority is quite important for the efficient protection and restoration of violated rights, especially when we talk about criminal cases, because there, this protection requires and should be as quick as possible. One of the important matters which is emphasized by the European Court of Human Rights and partially it is regulated by the draft is the matter of suspending the proceeding on the case, because it is obvious that sending the request, getting the consultative opinion takes some time, and it is included into the term of review of the case, and it is feasible to suspend the proceeding for this time. The draft 3120 reflects this idea, but the formulation is quite imperfect. If we formalize our draft, it obliges all courts, regardless of whether in their proceeding there is the case in which we should apply European Convention or we should not apply European Convention. In this case, it obliges all these courts to suspend the proceeding on the case only if there is de facto application to get the consultative opinion by the Great Chamber. I believe that it is obvious that the authors of the draft did not have this objective to block the activity of all the courts, so in this part it is feasible to improve the text and to give the right to suspend the proceeding on the case only the proceeding on the case on which the Great Chamber made the appropriate request to the European Court for Human Rights, and not absolutely in all the cases. Besides, the draft law doesn't take into account the possibility of giving to the National Court the powers during the suspension of the proceeding on the case and ability to restore the proceeding. For example, when there is the need to change one of the participants of the case by its legal successor, given that the court, according to Article 19 of the Constitution, has to act only on the basis within the powers identified by the law. I believe it's feasible to envisage these powers in the procedural law. Also, it is feasible to envisage other powers which are described by CHR in their methodological recommendations, in particular the powers of the Great Chamber to revoke the request, to add some additional information to the request, to inform the CHR on some procedural actions, replacements of the party on the case, to inform the CHR on the contact person for the purposes of the proceedings, to amend, to add to the request, and so on. The draft doesn't regulate the issue of the circle of procedural rights of the participants which may appear in the limits of the filed consultative opinion. In particular, this matter on the possibility of the participant on the case to initiate the matter of application to the CHR to get the consultative opinion. To request provides an unlimited to file written comments to participate in the case if there is proposal on that. And one of the most important matters for the Ukrainian judiciary practice for Ukrainian courts is the matter of significance of consultative opinion. Today, according to the Article 5 of the Protocol 16, the consultative opinions do not have compulsory force. And in principle, according to the law of Ukraine, the courts may not take into account these opinions, but given the importance of the case law of the European Court for Human Rights, and given that the procedural law establishes these requirements, the court decisions as justification, it is feasible to envisage the duty of the court in the national legislation, the duty of the court to give their motives in case if the court does not take into account the consultative opinion. Moreover, given that getting the consultative opinion takes some time, and this influences the term of review of the case and term of protection of the violated rights of the person who applies to the court.
Summing up, one can say that the issue of implementing Protocol 16 has not been addressed properly at the legislative level, and the adoption of the necessary legislation is necessary. Bill 3120 does regulate some of the issues, but it requires further improvement, in particular on entitling cassation courts to send inquiries for advisory opinion and expanding the powers of national courts within this advisory procedure. Thank you very much for your attention. Should you have any questions, I will be glad to answer them. Yes, we've got a question from Nazaris Ditsuk. He's seeking your opinion on the following: whether the advisory opinion should be sent in relation to the pending case or in abstract as well, where, say, Supreme Court identifies certain conflict in the interpretation of the convention, not directly related to a pending case. I am here in agreement with the ICTHR that advisory opinion can only be issued with regard to a specific case which is pending. And if the advisory opinion is necessary, is essential for the resolution of this very case. Thank you very much, Nina. That was the only question asked of you. As far as I can see from the chat, since we haven't got any more time left for any other questions, we will be summing up the results of this panel. And I would like to thank Nina and Andrei for their presentations. And the issue of implementing Protocol 16 in Ukraine is essential because Ukraine in 2017, once it ratified the protocol, thus showed its willingness to apply it. So what the Council of Europe expects from Ukraine is to complete the entire procedure through adopting the necessary legislation. We will be sending to you for your perusal, for your consideration and discussion of proposed amendments to the bill pending consideration in Parliament, after which we hope the Supreme Court will come up with its uniform position on the mechanism to be established by the law. And then we will be cooperating with all the stakeholders on this bill. And we hope that very soon this bill will be adopted into a law, and we will be discussing cases of advisory opinions sent by ECTHR and their consideration by the Supreme Court. I would like to thank all the listeners and the presenters. I would like to thank Mr. Stitsuk for his active participation in the forum. We will have a break now till 2:30 Kiev time, after which we will resume our work. Thank you very much. See you then.
Доброго дня, колеги. Ми розпочинаємо вчасно.
Good afternoon, colleagues. We start on time. Greetings to everybody who are working in the morning at this online platform of the 9th Annual International Forum on the Case Law of the European Court for Human Rights. This forum always reminded me of the point of collision of the oceans, international and national law, which change the atmosphere and legal climate in favor of humans, human rights, and freedoms. I'm Larissa Lysenko. I'm the lawyer and human rights activist. Today we will be guiding you to the end of the first day of our forum. I will tell you how we'll be moving, just some rules of navigation. We start our session after lunch. This is our third session on gender equality and access to justice in the case law of the European Court of Human Rights. After the third session, which I hope would be finished on time, about 16:10, we will move to the important presentation by Professor Rabinovich, and then we will have the module in which the members of the High Council of Justice will share how this institution uses the practice of European Court for Human Rights in their work. And I believe that around 17:10, as we have planned, we will finish the proceedings of the forum. Maybe we will be a little bit late. And now we start our third session. And the first speaker of the third session, Katerina Levchenko, the ombudsperson on the gender policy of the Cabinet of Ministers. Ms. Katerina, please, you can connect and you can start speaking. The presentation of Ms. Katerina covers modern tendencies in gender policy. Good afternoon, Ms. Larissa. Good afternoon, dear participants of the forum. First of all, I would like to greet everybody on the occasion of this important event before the International Day of Human Rights, which is very important. In my presentation, I would like to discuss the matters related to equal rights and opportunities of men and women as an important part of the policy, the issues of gender equality, which is an integral part of the human rights. It is the integral part of the public policy in this area. Could I share my presentation, or do we have the capacity to show the screen? Yes, sure. I have this capability. Okay. Okay, while we are connecting, I will start my presentation. I will start discussing the important areas of the policy and the fact that gender equality, as it is determined in Ukrainian law, is the equal legal status of men and women, equal opportunities for implementation, which allows the persons to participate equally in all areas of activity of the society. This is a very important definition and important postulate on which the modern state gender policy is based. And if we talk about the definition, what is gender policy? This is the policy which is directed at achieving this legal equal status, the gender equality, that is equal rights and opportunities for men and women. We know that annual economic growth of Ukraine could have been expedited by 7% or $7.5 billion if the level of employment of women would be equal to the level of employment of men. Today, we have the difference in pay, in engagement to paid labor between women and men, which is about 15%, 45.4% for women and 59.3% for men. Gender gap in pay on the same type of labor is more than 20% according to the data of State Statistical Service of Ukraine. And this is true, first of all, for official sector of economy, not the shadow economy. We understand that in shadow economy, there's difference in pay is even greater. At the same time, Ukraine has ratified the international documents in the area of human rights and gender equality. This includes the International Compact on Political and Human Rights, the UN Convention on Liquidation of All Forms of Discrimination Against Women, the Convention of the Council of Europe on the Protection of Human Rights and the protection of human rights and human freedoms. The International Pact on Economic and Social Rights, which are in the Beijing Platform of Action, which is the summer document of the 4th Global Conference of UN on the position of women, also which joins the Sustainable Development Goals. And recently, Ukraine joined the international initiative, which is called the Biarritz Initiative, the G7 initiative on gender equality, and it allows us once again to confirm, to reiterate all our commitments in ensuring equal rights and opportunities for women and men. The main areas of public policy which I discuss are defined in the law of Ukraine on ensuring equal rights and opportunities for women and men. The law was adopted back in 2005. It entered into force from January 1st, 2006. It is effective for 15 years now, and if we look at this wording, the main areas are reaffirming the gender equality. This means that the state has to carry out affirmative action and not just refrain from discrimination. Prevention of discrimination based on gender is not enough. We have to adopt affirmative action. If we use the UN Convention on Liquidation of All Forms of Discrimination against women, we have to use temporary special measures, which are quotas, for example, which are included into the Electoral Code of Ukraine, which allows this year to enhance significantly the level of representation of women in the local governments. To prevent and to counter the violence based on gender, to provide equal participation of men and women in socially important decisions. We talk about economic area, and not only this, we also talk about political area and economy and public administration. Also to ensure the equal opportunities for combining professional and family duties to support the family as responsible motherhood and parenthood, and also protection of society from the information which would be directed at discrimination based on gender. In the government program that was adopted by the Cabinet of Ministers, unfortunately it is not approved by the Parliament of Ukraine. This year we have a separate chapter to ensure equal rights and opportunities for women and men. And if we look at the wording, for us it is very important that the objective of the state policy is to take into account the gender component while approving the decisions of the public agencies, developing the goals of public policy and plans of implementation. We talk about not only the Cabinet of Ministers or the executive branch of power, we talk about all the public agencies, all the public authorities, which is the reflection of the principle of gender integration, the inclusion of gender component into all the areas of public policy, and particularly into the area of justice, and particularly into the area of law enforcement, and particularly into the area of criminal justice, the security and defense sector, Today, the state gender policy is not limited exclusively by the issues of social area, and it is not this implementation is not only the competence of the Ministry of Social Policy of Ukraine. This is very important because today we review the issues of gender components of the international technical assistance, in which every program, every project have to have the gender components. And gender oriented budgeting when in state programs and local budget programs are developed, taking into account the principle of gender equality. Also, we talk about gender audits of accessibility or non-discrimination expert review of the training contents. This is also very important to have these instruments which are implemented today. Gender legal expert review of the laws and regulations. Also, the instrument is awareness raising campaigns, communications targeted at dissemination of ideas related to gender equality. And at the moment, the government, in particular the Ministry of Culture and Information Policy, developed a plan of action to implement the concept of communication in the area of gender equality, which was approved by the government. Over the last year, we have adopted many documents which were signed by different agencies. For example, the decree on monitoring in the area of gender equality. The State Statistical Service of Ukraine filed the document which implements 226 indicators, which will be collected in order to be able to have scientific approach to reviewing the ensuring of gender equality. 104 of them will be collected by the State Statistical Office of Ukraine, and 122 will be collected by other public agencies. The example of communication strategy was mentioned before. Recently, the international new second plan of action was approved to implement the resolution of the UN Security Council 1325, Women, Peace, Security, which dedicates a lot of attention to the system of judiciary, restoration justice, protection of victims, including the victims of sexual violence related to conflict. It says that this circle of entities of implementation of public policy is always expanding. We talk about executive branch of power. The coordination of gender policy is performed by the Vice Prime Minister on European and Euro-Atlantic integration. Ms. Olga Stefanishina is a responsible person in this area. The Special Coordinating Commission was established for interaction of public agencies to ensure equal rights and opportunities of women and men, again under the chairmanship of the Vice Prime Minister, in order to make sure that different efforts that are implemented in different areas are unified in terms of approach, and to make sure that the policy is efficient and is targeted at achieving specific goals which are formulated in the Sustainable Development Goals in particular. In Ukraine, we have established a strong legal framework in the area of equal rights and opportunities for women and men. This is also very important, that the policy is based on strong legal framework. And the law I mentioned before on ensuring equal rights and opportunities for women and men, the law on the basis of state policy of prevention and countering discrimination, on countering and prevention of domestic violence, national strategy in the area of human rights. For fulfilling this law, we have developed many resolutions and plans and decrees, and also orders of the central public agencies which review specific documents for implementing policy, the analysis of gender impact in different sexual reforms. Today, We're moving further, as I said in the beginning of my presentation, in the gender integration and the inclusion of gender components in all areas of policy. The important objectives for 2021 are the ratification of the Convention of the Council of Europe on prevention of domestic violence and violence against women and fighting this phenomenon, and implementation of the commitments with Ukraine to counter the partnership of berries and strengthening gender components at the local level. Because in the process of decentralization, we establish new structural units, and so there is a need to make sure not to lose this work, and improving the practice of countering violence, gender-based violence, implementation of communication strategy, because the plan will be adopted in the beginning of the year, and countering the manipulations which appear in the field of gender policy, which are related to substitution of notions, substitution of facts, fake logical judgments, frightening of activists who deal with these issues. The objective is to separate Ukraine from general European content from the values which we call European values, which are based on the principles of rule of law, democracy, protection of human rights. I would like to give several examples of these manipulations. And one of the key ones is the presentation of the terms gender and sex as they identical. That is, the term gender, as they say, is the same as the sex. If we always substitute gender, the notion of gender and sex, we have very strange things, given that gender is social sex, which forms the behavioral, cultural, psychological, visual, and other socio-cultural differences between women and men. And sex is used for identification of biological, anatomical, physiological differences between women and men, between the bodies of women and men. When we talk about gender roles, which are different for men and women, the presentation of this notion as identical leads to some ideologists of anti-gender. These ideologists make the conclusion that there are many sexes and gender policies directed at person changing their sex or the opposite. We should not have men or women, and we should come to no-sex society. This is one of the key manipulations on which other manipulations are based. So when I speak to you, I'd like to draw your attention to this, that the notion of sex and gender are not identical. They cannot be used as synonyms. They relate to one domain, but they do not characterize. They characterize different phenomena, and understanding of these notions and understanding of areas of policy, which I presented, demonstrate that gender policy allows for development of different social groups, for development of human personality, regardless of sex. Because manifestations of discrimination in modern society are many, and gender policy is the important area which allows us to implement the highest standards of social justice, which are formed by international documents in particular. Thank you very much for your attention. If there are questions, I'm ready to answer.
And Larissa, our moderator, will tell us if this is at all possible. Thank you, Ms. Levchenko, for this overview of the latest developments in Ukrainians' gender policy, and I invite all of the participants to ask questions of the speakers. You can do that while they are speaking in the chat box, because our time is very limited. Ms. Levchenko, there's a question to you. Whether the Constitution can be gender sensitive and whether amendments to the Constitution are required to this effect. Thank you, Andrei, for this question. I can tell you that there are certain controversial norms in the Constitution. There is Article 24, on the one hand, stating the equality between women and men in various spheres. On the other hand, there is an article that limits the use of women's and underage persons' labor in hazardous types of work. It's a separate issue about the limitations instituted just to protect, quote unquote, women. It's part of the paternalist approach and an attempt to protect women. But the ILO has formed its approach to the need to protect motherhood, not just women in general. And I can tell you that the use of the notion women, underage person is also discriminational when used in the same context, in the same sentence. So this provision of the Constitution should be revised and updated to meet international standards. Thank you, Ms. Levchenko. I've got a favorite part of Article 24 that says that equality of rights between men and women is ensured through giving women equal rights and opportunities with men. It looks like women are given some rights that are inherent in men under the Constitution. That seems strange, doesn't it? So we will be moving on, and I will give the floor to Mr. Pavlo Pushkar. He is head of division of the Department for the Execution of Judgments of the European Court of Human Rights, Council of Europe, and he will be speaking about reinforcing zero-tolerance stance against domestic violence. What kind of role for the judgment of the European Court of Human Rights is there? So, particularly in the context of the case Volodin versus the Russian Federation, and there the court performed the function of the Parliamentary Assembly of the Council of Europe, noting that the policy of the government of the Russian Federation is atrocious in terms of a lack of countering to the domestic violence in the country. We've got first judgments against Ukraine in this area in the context of domestic violence. So, Pavlo, the floor is yours. Good afternoon, esteemed moderator, esteemed ladies and gentlemen, participants of the conference. Thank you very much for inviting me to participate in the 9th Forum. I would like to thank the organizers, Lviv at Ivan Franko University, the Supreme Court, the National School of Judges, the Council of Europe, and OSCE PCU for bringing us all together. The issue of gender in the context of the ECTHR case law is extremely important, and it is very topical for Ukraine in the context of our international legal obligations and commitments and the Istanbul Convention. I will be speaking about reinforcing zero-tolerance stance against domestic violence and the role of the ECTHR case law. I'll be speaking about it from the angle of the academician rather than the representative of the legal profession as a representative of the department. So I believe And I would like to start with the following. The topic of feminism and equality of rights between men and women is extremely important to Ukrainian society. I will not speak here about sexism, pay gap, and participation or lack thereof in the political life at the top level, which is manifested through domestic violence as a dimension of this inequality in the context of the role of women in the state building and statehood development, in particular active and passive right of women based on the Ukrainian People's Republic in 1917, or special status of women and their property in the context of a Ukrainian inheritance law. I would raise a couple of questions for discussion, and they will be linked with the skepticism that Katerina mentioned before with regard to the gender equality issues and feminism issues. And I would start with feminist opinions on the international law and implementation of its standards, in particular, the implementation of international law in the area of human rights. We would look at the EU acquis and the law of the Council of Europe in the context of non-discrimination and equality, and the issues of the implementation. The judgment in Volodin's case was mentioned already, and it can be a very interesting segment of our discussion. I'll start by saying that the talking points that I'm going to make today were mentioned during the forum in Kharkiv, and I would like to present the neutral view of the feminist position in the international law theory without referring to the documents developed by men. I would start with some caveats or reservations. The topic of feminist views on law and international law in particular is a topic, as well as the topic of gender, does not threaten the doctrine and theory of international law, nor does it set up a problem of fragmentation of the international law. So the establishment of the parallel international legal obligations that would compete amongst themselves. By the contrary, it enhances the diversity and wealth of these opinions, which is a characteristic of feminist views of the international law. The very conception of feminism, concept of feminism in the international law is about creating level playing field and impacting this area of international law for both men and women, and leveling the inequalities that took hundreds of years to entrench. Indeed, theoreticians of feministic views of international law fall into 4 or 5 major concepts: liberal, cultural, postmodern concepts of international law. But I think that the most topical to us is the theory of cultural feminist opinions that brings together a deeper theoretic view of what international law is, what are the issues of the international law today, and what are the issues of substantive and procedural equality of men and women in the international law. So this approach rather reflects the approach of sociologists to international law and the criticism positivism view of the international law. That is the vision of the key role of human values for the forming of the international law, rather than the role of sovereign countries as the only subjects of international law. These approaches also take on board the in-depth analysis of the so-called intersection, that is the combination of 2 or more indicators of inequality in the context of biological sex, and I will comment on that a bit later, and Katerina Levchenko referred to it earlier. In particular, it is about bringing together the factors of differences and specific vulnerability like race, ethnic origin, religion, sexuality, property, etc. And this analysis is interesting from the point of view of this concept, which is mentioned in the judgment Garim versus the Netherlands, with interesting dissenting opinions of Duppenkerk, Bakapovic, and some other justices. A couple of words about the liberal and radical discourse of feminism in the international law. There are various discourses about public and private areas of international law, including a limited role of women in the formation of international law and activities of public institutions in the international institutions. And we can agree with that in that the influence of the international law on public and private law is not quite clear, nor does it mirror the conception of the horizontal spread of international human rights, the so-called Lviv concept. There's also an approach to the international law as a paternalist construct, and we are discussing this provision of the Constitution that is established by men for men, just as a hegemony of men over women, which challenges the universality and inalienability of human rights. At the same time, there are certain requirements to support the weak norms of inobjective, non-objective international law, and it prevents countries from requiring that they abide by this law, because they create this cognitive dissonance. There's also a simplified quantitative approach to the participation of men and women in the activities of international organizations, international public institutions, and decision-making. Instead of the in-depth assessment of the impact of men and women's participation and the assessment of the existing constructs, there are numerous examples of quotas for women's participation, and here I will refer to the Constitution of Kosovo, or quotas for public servants, judges, and members of international institutions. So the criticisms of limited impact of women on an international legal instrument whereby women understand the legal problems better, like certain procedures about the proceedings in crimes against humanity in the Tribunal on former Yugoslavia, is also part of this feministic approach to international law. The above, I believe, with a view to the existing assessment of these issues, remains factological rather than the legal discourse, aiming not to resolve these issues, but rather to highlight them, even though these facts are useful for the academia because they fight the stereotypical thinking. But I believe that the in-depth research of those issues and those matters that can be implemented from the stance of the impact of women on the formation of the international law is more interesting. And it leaves beyond this discourse the role of women as a driver of change and transformations of public processes and institutions that are raised in the UN and the Council of Europe. The understanding of the criticism theory of feminist theories that is sometimes compared to archaeological excavations where different methods are used to excavate various layers of the ground. And this depth of opinions of the international law is extremely important for historiography, for the analysis of the existence of the prejudice norms of international law. And we should look for the common ground of these approaches from radical and liberal concepts that pay mostly attention to the recognition of the international law as the really existing one, and they study the issues of legitimacy of the international law, international institutions, and an issue of implementation of norms and compliance with the norms. of the international law. And what Katerina Levchenko focused on is the shift of focus, actually, of paradigm from the role of women and as mothers. And this new stress, this new focus is on the role of women in the international judicial institutions and other international organizations. I would not speak here about gender equality and non-discrimination that are covered by Article 14 and and Article 1 of Protocol 12. On the court's site, you will see a lot of judgments pertaining to this area. It's also about gender mainstreaming, and there are several interesting judgments in the cases like Konstantin Markin versus the Russian Federation. And I would like to refer here also to one paragraph of this judgment 127, that referring to ethnic and national traditions or the prevalent attitude to women in the society cannot be seen as substantive enough a ground for forming attitudes to women. So we can say that this judgment and the one in the Volodin case also is in line with this tenet. The court growingly often pays attention to various factors of vulnerability and inequality in this context. In conjunction with other objective factors, it enables a comparison of discriminatory practices towards men and women, and these can be different. The practice of the court vis-a-vis gender issues and non-discrimination is broad and diverse. Quite recently, ECTHR published the compendium of case law on non-discrimination, and some of that pertains to reproductive rights, a separate compendium on the issues pertaining to the participation of women and men in political life, and about the prejudice of women judges towards men and vice versa, particularly when it comes to issues of adjudicating non-discrimination or discrimination cases. And there's a one study about how many men usually complain about gender discrimination to ECTHR and win those cases. And this study corroborates the fact that men are more frequently the applicants to ECTHR seeking redress of their violated gender rights. Now to domestic violence, I hope I've got a couple of minutes. And I'm close to the end of my presentation. The topic of domestic violence is actually on the top of the agenda for ECTHR, and it is about the positive obligation by the state to consider such cases, particularly in the context of Article 3, Butruga versus Romania of 2020, and the issue of efficiency of the investigation and procedural aspects of the case, both disadvantages in the activities of the law enforcement authorities due to complaints within Article 4 against Croatia on the prohibition of slavery, and on the issues of privacy and support to the privacy of correspondence. And here we can single out the decisions of the European Court for Human Rights, like Corpus versus Turkey, Yeremia versus Moldova, Stalkis versus Italy, and others. The best practices in the context of these cases and judgments in terms of their execution is the introduction of a systemic approach to eradication of domestic violence as a notion, as a phenomenon, through persecution through coordinated policies in the state on these issues. This systemic approach, according to the Committee of Ministers of the Council of Europe, is manifested in the manifested in the ratification of the Istanbul Convention. And this path was opted for by Moldova, Georgia, Turkey, and I can see that Mers Bartolome is going to speak about it, so I won't provide you any more detail on this issue. And I would glad to hear from Ms. Levchenko that Ukraine is planning to ratify this convention, even though the presidential decree on the 20th of September does not contain any reference to the ratification, but I still hope against hope that it will take place. Now, nor will I be now analyzing legislation of 2018 on countering domestic violence. I would rather go to the last part of my presentation about Ukraine's path. That we do have certain myths about the convention. The issue of gender as a social phenomenon that Katerina referred to. Some people still believe that it is an issue in Ukraine, but conservatives in other countries also believe that this convention introduces gender ideology into their domestic law and in the international law. In the context of Ukraine, we've got several judgments pertaining to the issue of domestic violence. Nirina Smirnova versus Ukraine. Substantial delays in the investigation of complaints about domestic violence, procedural protections or procedural sidelines, and Savchuk versus Ukraine, Article 8, non-proportional decisions of the Supreme Court on eviction of the applicant from the house of shared with or cohabited with the perpetrator. This judgment has not yet entered into force, and there was an application to actually refer this case to Grand Chamber, so I am not in the position to comment on it now. So I would like to also specify that that within the implementation or execution of ACTHR judgments in the area of domestic violence, Moldova and Italy show best cases. We should say that the Istanbul Convention is lex specialis vis-a-vis the European Convention on Human Rights.
This is recognized not only by the number of states of the Council of Europe, the Committee of Ministers of the Council of Europe, but also this is recognized by the European Union on 13 of December 13 of June 2017. It has signed the Istanbul Convention, and now the issue of ratification of Istanbul Convention is reviewed in the European Court of Justice in Luxembourg. Yesterday, I have looked at the information on the review of this case. Final information is not available yet, but the draft ratification of this convention is the priority for the strategy of gender equality of the EU and the main priority for work of the European Commission for 2020-2025. It is a very important segment, and in the cases like Demetian versus Moldova, Bolsan, Opus versus Turkey, Staupis. It is mentioned that there is a need to ratify this convention. The practice of recognizing the convention as the best systemic instrument of countering domestic violence coincides with the European integration aspirations of Ukraine. And it proves that the Istanbul Convention is the legal and politically necessary for Ukraine. At the end, I would like to mention that I sincerely hope that today's forum will give the momentum, and this discussion will give the momentum for adoption and implementation of the systemic approach to countering domestic violence. Maybe it will change this forum. It will change some priorities concerning the issues of gender and gender equality, the problems of zero tolerance from the perspective only decisions of ECHR cannot be decided by means of only execution of the decisions, the instruments like Istanbul Convention once again are extremely important. As now at the end, I'd like to give several advice to those who are interested in gender research, gender studies, where to start this research of gender equality and domestic violence, the basic settings. First, I recommend to start with the literature and music. I'm very glad that Ms. Larissa is present here. Maybe she could recommend something additional. I would like to recommend the alternative view on the issues of sexual relationships and equality between men and women from the book by the writer Ursula Le Guin, Left Hand of the Darkness, 1969. I think that this book will create serious impression. It's impressed me a lot in the past. For the most interested people, you can study the creativity and citizen position of John Lennon, Yoko Ono. They pay their attention to the issues of gender equality many times. It's not only in music. Also, modern situation of pandemic, we can start looking serious. Queen's Gambit, I really recommend it. It may change the view on some stereotypes regarding women. And for the lawyers, I suggest to find the definition of feminist punk in the base of European Court of Human Rights. And at the end, I'd like to say that I fully agree with the statement by the Secretary General of the Organization of the United Nations, Ban Ki-moon, that the countries with greatest gender equality have higher economic growth, the companies with more women better and more efficient, peaceful agreements which includes women are more long-term, parliaments with participation of more women adopts better laws on basic social matters like health, education, anti-discrimination, and support for children. And in principle, the global practice demonstrates only one thing, that equality for women and men means the progress for all. Thank you very much. Thank you, Pavlo, for Brian's presentation. The only thing I would request you to answer in the chat for the specific questions which were asked. If we have responsible speakers, I would, if they don't follow the time, I would deprive them of the opportunity to answer the questions in the chat. We have to move forward. In terms of Istanbul Convention, I would like to remind you that yesterday the first forum of Minister Interior dedicated to the counter and violence view of 360. There was collection of materials on the mystification of Istanbul Convention. All these fears which you mentioned when you discussed this, they were trying to put them in simple language to expose them and to discuss what really may be the effect of Istanbul Convention. I hope that the president, despite the decree which solves many things in parallel without ratification, or at least it tries to do so, it would be submitted to the parliament for ratification, hopefully. Now I invite for the presentation Tatiana Faley, the chief of the Department of Scientific Research of the National School of Judges, the expert and coordinator of the projects for OSCE, the expert of the project coordinator of OSCE in Ukraine, gender equality and access to justice, the common points. Thank you, Larissa. I'm very pleased that at the 9th Forum, finally, we have special session dedicated to the problems of gender equality and access to justice. I would try to share the presentation. I believe it will be successful. To start, I would like to mention, I'd like to thank Katerina Borisovna. She founded the issue of terminology and she continues this in the chat. Also, in my presentation, I will try to cover several terms and importance of these terms for understanding where we are, what are the common points, and where should we be moving, and relation between term equality, between the terms sex and gender, when we understand the difference between these terms. When I was studying the case law of the European Court, my conclusion was that the problem of gender equality, the European Court for Human Rights started to dedicate more attention to this almost 30 years ago, and no doubt not using the term gender equality yet at that time, but back in the case of Schuler, Gragen, the court used the term equality of sexes. And in the case Leyla Shahin versus Turkey, this is the decision of Great Chamber of the early 2000s, there was the term gender equality. And we can see in the case, which is the key case, Carvalho Pinto de Sousa Moraes versus Portugal, there is the phrase gender equality, but this lengthy mentioning in the recent decisions allows us to make the conclusion that we talk about the same concept, which 30 years ago was declared as one of the values of the Council of Europe. And when we evaluate the motivation of national courts in some case, the European Court, if the case was about gender problems or discrimination based on sex, it analyzed this from the perspective of gender equality or equality of sexes, if this was in the middle of 1990s, as one of the objectives of the Council of Europe. Thank you very much to you and to Pablo for initiating this discussion about the myths. And we did not agree in advance, but I gave this long read which our colleague Helena Slavinska in the interview 1 year ago with Dmytro Kuleba. You should read this interview, what attracted my attention was it's very hard to object. It says that you can ask what's your attitude to gender equality, or you can ask what's your attitude to equality of women and men. And in different formulations, you can expect different answers. And in these issues, the terminology is very important, and these issues are so sensitive that unfortunately this sad case of non-ratification of Istanbul Convention it demonstrates that at that stage the myths won, and they are related to interpretation, not even interpretation, but the notion of gender. And we remember this discussion and these expressions in the parliament. I will not stop in detail on the case law of the European Court in the cases which concern problems of gender, because this topic is well developed, so the decisions are well known. The only thing I will try to cover, I'll try to group these cases, and the greatest number of cases, and the greatest number of decisions, and the greatest quality and diversity of decisions related to application of articles of the 14th Convention in combination with the appropriate substantial article. In this case, we can talk about diversity of legal relationships and diversity and great number of articles of the Convention, which the rights which are guaranteed by the Convention in combination with Article 14, the cases related to domestic violence, in which we had Article 2 and Article 3. Also, the rights for fair trial, in particular, the requirement of fair trial in the proceedings related to gender-sensitive cases. We have great practice on Article 8 of the Convention. On Article 8, in combination with Article 9, sometimes the court reviews these complaints on these articles together, which cover the wearing of clothes by Muslim women. Article 1 of the first protocol, Article 4, ban of forced labor, and so on, and others. But the review of complaints through the prism of discrimination is not the only way. There is significant case law where, first, the court reviews the complaint on the matters. Most of all, it was Article 8 and Article 3. And I have to note that the court analyzed the cases in terms of intervention, so-called negative commitments, and also fulfillment of positive commitments by the state, and the efficiency of investigations. These cases covered the aspects of implementation of positive commitments according to the convention by the states. It's important to emphasize that the need to ensure gender equality. In particular, this was clearly mentioned in the case SAS versus France. It is legitimate objective, and here we have to remember about this three components test, and overall about the algorithm of reviewing the cases in the European Court. And it's one of the legitimate goals which we may limit some rights, and we may have some interventions into the rights. And the court analyzes if it was legal intervention, if it pursues legitimate goals, and if it is necessary for a democratic society. This component or this element of legitimate goal, one of the legitimate goals is maintaining gender equality, and we have a number of cases which develop these provisions. As it was mentioned before, the strategy of gender equality of the Council of Europe, it has the number of strategic, it has 6 strategic areas, and if we analyze the decisions of the European Court which concern the gender problems, we may say that at least they include first strategic goal. There is the case law related to gender stereotypes and avoiding gender stereotypes and sexism and fighting this phenomenon is one of the priorities, as it is mentioned in the strategy of gender equality of the Council of Europe for 2018-2023. And here we may remember what Pablo mentioned, Costin Marken case and Carvalho Pinto case, which has special weight for the judiciary because the basis of motivational part of the decision of the High Administrative Court was these gender stereotypes. And we remember Bright's presentation by the judge Hussein of her last year, and the last year forum gave this case as the example of non-relevance of justification. And another strategic goal which is identified in the strategy of gender equality of the Council of Europe is prevention and fights in violence against women and domestic violence. And this collection of decisions starting with AUKUS and Moldova cases, and unfortunately our case, Levchuk case, it will serve, I hope, to achieve this strategic goal if the measures are taken, the measures of general nature are taken. The access to justice, our session is called, it is dedicated not only to gender equality, but also to access to justice. Emphasizing the importance of terminology, I would like, first of all, although it seems obvious, but anyway, I would like to underscore the difference of notions and the difference of concepts which they mean, and the access to justice is the notion which is used in the famous presentation of Venice Commission on the rule of law, and in the control list which was the annex in 2011 to this presentation. In 2016 it received the independent confirmation, and this rule of law checklist is well known in our country and also in other international treaties which are ratified by Ukraine, like well-known Orhus Convention or the Convention on the Rights of People with Disabilities.
It's the
There is
terminology on
the concept
access
of
to justice, which is different from access to a court. Unfortunately, we still have to read and see in some academic publications, and not only there, that sometimes these terms and these concepts are used interchangeably, where access to justice is seen as a component of Article 6. We can discuss, of course, the reasons for this issue. Perhaps it is or it can be put down to the lack of knowledge of English terminology, but we have to discriminate between these two terms and notions and understand access to justice as a broader concept which cuts across all elements, covering not only the components of Article 6, but also, if we speak about potential standards, also Article 13, as the right to effective remedy and some other elements. Then access to a court from the Golder case is a much broader concept, which is about the right to file a court case. So for want of time, I won't be commenting on all of the characteristics and the history of this notion. I will only give you certain points, bullet points, that it is a cross-cutting element when it comes to access to justice. It's just a cross-cutting issue in terms of the rule of law and all the institutions when you can seek remedy or redress. Then a very clear and practical character of research. Starting from the 1960s until now, we have a lot of publications, I would say not 3, but even 4 waves of such publications, even in the pre-COVID era. And I think that the development will be going in that direction. In many countries, when speaking about access to justice, conducted the national debate aiming to make sure that there is a need to address the issues relating to providing legal aid, actual and legal access, efficiency and effectiveness of remedies, including the classical legal remedies and alternative ones, like mediation and other ADRs. So this concept, this notion is developing, and even though it is not part of the convention, we still can predict that ever more researchers, academics, and legal professionals will be paying attention to it. In this context, I would like to emphasize also that Evgen Burlai, in his recent article dedicated to the limits of viability of the law, said that he was a proponent of terminological or notional monism. One term corresponds to one notion. no synonymity in terminology, which I also agree with. And the issue of access to justice should not be replaced or substituted with notions that, albeit being very important, like hunger for well-qualified stuff or judicial self-governance or self-regulation, still should stand clear. And if we analyze the content of the discussions in the Ukrainian society, the national wide discussion on access to justice, these are very important issues, of course, the lack of the judicial cadre, but still it is not the core of the notion of access to justice in its classical meaning. And now speaking about intersections. The most notable, I think, if we look at the gender equality strategy of the Council of Europe, amongst all those 6 priorities mentioned before, we should look at priority 3, ensuring equal access to justice for women. And it is important to say that gender equality is not just about ensuring or improving the rights of women and equality of those rights. And it's important that amongst the proponents of this topic, there are both women and men. Considering these issues and considering this strategy, I would single out from the entire list of actions encouraged by the Council of Europe, only 2. I can't say that they are more or less important than the others, but I think we should think more about them. And the sooner we start implementing them, the better we perform in ensuring gender equality. And that is encouragement of research and standardized data collection, which will be disaggregated on gender disaggregated, and then adoption of new legislation on statistics to make sex or gender disaggregated data mandatory. We still lack adequate statistics. We still lack reliable statistics, particularly when it comes to women's access to justice. Whereas in the area of criminal justice, there is some statistics related to, say, the inmates, women, or persons about whom sentences have been pronounced, particularly in terms of persons of age and persons underage. Then when it comes to civil cases or administrative cases, we don't have any statistics whatsoever as for what genders go to courts for what categories of cases. And the second one is monitoring and research, capacity building and education, promoting best practices to debunk gender stereotypes and to weaken their impact on judicial decisions. It is a challenge, I think, particularly given the judgments of ECTHR that we all know, which illustrate this adverse impact, sometimes not even well thought of when it comes to badly motivated court decisions, but also in order to avoid further violation of rights, individual rights, when it comes to gender equality in access to justice. working to understanding and overcoming gender stereotype, I believe, is extremely important. Thank you very much for your attention. Should you have any questions, I'll be glad to answer them. Thank you, Tatiana, for the presentation. We've got a very interesting question in the chat. I hope you would be able to answer it, but please do that in the chat as well. Since we have very little time left, I would encourage you to answer it in the chat and everyone can read it. Now I will give the floor to the gender advisor of the Council of Europe, Ms. Murray Patasalmi, and she will be speaking about women's challenges and barriers in accessing justice during the COVID-19 pandemic, which is extremely topical and relevant to the situation in Ukraine. The floor is yours.
Thank you for the organizers for inviting me, and thank you for the previous presenters for interesting discussions. And I think that my presentation will go well together with the other presentations. And as was said, this will be quite topical. So I will be talking about women's access to justice and challenges and barriers in that during the COVID-19 pandemic. Let's see, I will try to share my presentation. Hopefully you will be able to see it. All right, as was mentioned, my name is Mervi Patasalmi. I'm the gender advisor for the Council of Europe office in Ukraine. And I will start first talking a little bit about the gendered effects of the pandemic, more in a general sense. And I think that this pandemic has really highlighted and exacerbated differences both within countries and also between countries. And this also, I think, applies in many cases to gender equality and human rights. And of course, the study on the effects is still ongoing, but already there is some preliminary results, and we can see some effects. And I have put here some gendered examples, meaning that women and men have experienced these issues differently. And firstly, there is the question of health. And in there we can examine direct and indirect effects of the COVID-19. And there is research showing that men have been more severely affected by the COVID itself, meaning that, for example, mortality rates have been higher, or they have become more ill due to this. But one can also question what are the indirect effects of the pandemic to health. So whether it's about untreated illnesses, postponed treatment, and so on. And I think that these are some of the things that we won't find out until maybe some cases years later. And it is something that we need in really study on the effects on different genders. The second issue here is the employment. Of course, we know in Europe, 76% of healthcare workers in the European Union, for example, are women. So of course, women have been really affected by this pandemic. But I have put here a question of who is an essential worker, because when we start to think about what are the essential elements during these type of times, for example, are cleaners, especially those who clean in hospitals, essential workers, whether shop assistants or people working grocery store, teachers, other care workers, and so on, are they essential workers? And I think that this really kind of also reveals the gendered effects of the pandemic. Of course, there are effects on industries. They are different. Service sectors, for example, restaurants and other service sectors, small businesses have really been hard hit. And in many parts of the world, women are more likely, for example, to be self-employed, whether it's in the wellness sector and so on. which means that the effects of this pandemic have been harder on them. Then there's the question of gender-based violence and various forms on this. I will talk about this more later in my presentation, but I think that it's good to remember that there are also other forms of violence that has increased in addition to domestic violence. So we can talk about forced marriages, female genital mutilation around the world, and so on. Then there is the question of care responsibilities. I already mentioned the paid care work that is mainly done by women, but in addition, women are responsible for the care work done in families. So when people have had to stay at home, when schools have been closed, and so on, women have really haven't really taken on the care burden in families, whether it's for children or for elderly or so on. I put here also the question of politics and how the emergency response has been managed and how it has been really dealt with in different countries. And we can, of course, question how the rule of law has been upheld. Has there been analysis of emergency measures? Because often the fact is that people who are already in vulnerable positions will be more heavily affected, whether it's about minorities, immigrant communities, cutting of services for mental health, substance abuse, and so on. So this is one of the questions that I think it's good to keep in mind, that how we really are measuring the effects of various kinds of emergency measures. And anecdotally, it has been mentioned that governments that have been led by women have handled the crisis better. I think Pablo mentioned about the connection between gender equality and democracy, economic success, and so on. And I have found one academic article that has really analyzed this connection, and it seems that there is a statistical connection between how well the country has dealt with the COVID and whether they are led by women. Of course, we can speculate whether it's about the gender of these leaders or whether there are other issues that are connecting these countries. So we're talking countries like Norway or Finland or Germany or New Zealand. So it could be that there are other issues as well, but at least there is some statistical connection. And also, when hopefully next year we will be coming out of this pandemic, it is really important to ask how various recovery efforts are being managed and how they will be directed. Who will benefit? Already the European Union, for example, there is a massive recovery packages agreed. Do we know the effects where these type of support is being directed? So I think that it's really important also to keep in mind when we are coming out of this and the recovery efforts are being done. So this is really the background of the COVID pandemic, and it creates the background also for women's access to justice and to the challenges and barriers when it comes to this. I will now look more detail in the access to justice in regards to gender-based violence, and I'm firstly talking about international context. It's clear that during the pandemic, police and justice sector have been really overwhelmed, and they have had to shift priorities. Whether it's about enforcing quarantine, social distancing, there has been various kinds of public unrest in different places and so on. And this has also created, for example, situations where protection orders have not been enforced, which has also affected access to justice in cases of gender-based violence. Due to the social distancing and lockdowns, courts have been closed and hearings have been postponed, which has created backlogs of cases, which again is exacerbating the problem. In many parts of the world, informal justice mechanisms are ways of dealing with gender-based violence also. So these have been affected due to the social distancing measures and not being able to gather together. There is also inability to report violence due to there being no privacy. If there is a lockdown and you're living with the perpetrator, the situation is really challenging. But also the economic problems, meaning that people are unemployed, they stay at home a lot more, have created situations where often the victims are locked in with their perpetrators. And finally, I have put here the question of digital divide, because I think that this is something that is not often talked about. When services have been moved online and we are starting to use more digital services, there has been a divide in this. Not everybody has the skills or the technology to access these services, which is again widened the inequalities that have already existed. So this is the international context of the COVID and in regards to women's access to justice when it comes to gender-based violence. Of course, these similar can be seen in Ukraine. There is an increase of violence, and this has really been reported. The hotlines have reported that in some cases there has been doubling of the number of calls to hotlines. The number of court decisions on issuing restraining orders has decreased. In some cases, there's been, for example, reported 38% decrease when it comes to the beginning of the year, which I think is really quite a lot. The similar issues of forced lockdown with the perpetrators, it's of course present also in the Ukrainian context. And then there is the lack of specialized shelters and in general difficulties with access to legal aid and social services. And it's also good to remember that even during the Norman times, there is issues in regards to access to justice when it comes to gender-based violence in Ukraine, because many of the judges and prosecutors are really struggling to see domestic violence as an issue that is not inside the family. There's difficulties in getting protection, emergency protection orders, or the court restraining orders require really long and difficult processes. So I think that these issues, again, have been kind of highlighted and exacerbated during COVID. If we then look at the tools to improve the access to justice, and of course, Istanbul Convention has already been mentioned by the previous speakers, and I think that this is something that is good to talk about, and it is really a comprehensive tool and a unique tool in regards to combating gender-based violence and also to improve access to justice. And there are lots of myths about the Istanbul Convention. Council of Europe has produced the video on this, so I think that it is also important to get information out about the reality or the real facts of Istanbul Convention. And I have also put here the name of the full name of the Istanbul Convention, which is Convention Combating and Preventing Violence Against Women and Domestic Violence. And really the name says it all, what it is about. It's about combating violence, not about other issues. So I think that this is something that is good for all of us to also keep in mind what this really is about. And the Istanbul Convention is about 4 Ps. I can say that in Ukrainian, the 4 Ps doesn't work quite so well as it works in English, but I think that the issues are still the same. So there is the prevention, protection, prosecution, and policy coordination. And I won't go through all of this in detail, but what I want to highlight here is really that in emergency situations, I see that especially the pillar on protection and coordinated policies become important. Protection because of the immediacy of the problem. So in emergency situation, protecting the victims of violence is primary, as I see it, and this is something that really becomes even more important. Also, coordinated policies become really important in situations that are difficult. It is important that the different sections work in a coordinated manner, whether it's about police, justice sector, social services, or the civil society providing various kinds of services. So I think that in difficult situations, this coordination becomes even more important. And of course, then prevention and prosecution are also important, and especially in the longer run, that we can really prevent. We need education, we need training, and in order to bring perpetrators to justice, we need prosecution. The second issue that I've raised here as a tool to improve access to justice is the European Court of Human Rights, and already the cases have been discussed, and the recent case concerning Ukraine, I put it here just an example, even though the process is still ongoing, because I think that this is also a case that connects to the COVID situation in this, that the importance of victims' rights and the state's responsibility to assess the risk of violence is really paramount. And even in cases where the complaints of domestic violence have been withdrawn by the victim, it is still a state's responsibility to protect the victims. And of course, forcing to live with the perpetrator during the COVID times has been an issue. So I think that this is an example of case where this also is highlighted. One of the tools to improve the access to justice during these kind of times really is recalibration of the justice system. And this can mean different kind of things. There can be a different kind of solutions dealing with domestic violence, whether it's about priorities, that certain cases are given priority, for example, treating protection orders as urgent, whether it's about virtual services or mobile justice units, so that really the access to justice is guaranteed even in cases where the physical mobility or physical spaces could be closed. Also, including women in planning and in decision making is really important. Whether it's about consultations with civil society actors, NGOs working with domestic violence, whether it's about women judges, whether it's about police officers and so on. So I think that these are important in doing assessment and evaluating different kind of policies and what are the effects. Again, addressing the digital divide, I think it becomes really important during these kind of times when a lot of services, a lot of activities are transferred online and to digital services. It is important to have a solid understanding who actually has access to these services. And then having this understanding, training is needed, whether it's about training the authorities or whether it's about training those who use the digital services. So I think that this is something that is good to keep in mind. I think that sometimes the technology is seen as a way to solve a lot of the issues, but it's good to keep in mind that there is also a gap in this. Whether it's about poor women elderly women and so on, they may not have skills or the technology to use these services. And last issue here is the gender impact assessment and the importance of data and evidence-based approach. And this is really important. I have actually put another slide about this because I think it's really important to do gender impact assessment of legal acts. It is important to analyze the effects, whether it's emergency legal acts or as part of the normal lawmaking, the effects on human rights and on gender, on men, on women, on boys and girls. And this is often a problem during emergencies. I know that even in countries where gender impact assessment is part of the regular procedure during the COVID times, even they have not been doing the gender impact assessment during their lawmaking. Sometimes it's a question of capacity, whether there is really the capacity to analyze it. But I want to really emphasize gender impact assessment as a systematic part of lawmaking, because this is a way to ensure that there are no unexpected consequences, or at least diminish or reduce the unexpected consequences. It enhances the legitimacy. It enhances the resilience also of whatever is being decided on, because there is a better understanding of the impacts and the effects of the laws and various other kinds of acts. So as a conclusion, I think that this COVID pandemic has really revealed something about our societies, whether it's, as I mentioned, between countries or within countries. So certain kind of inequalities have been made bigger, and they have exacerbated. And those who are already in a privileged position have been able to telework from home. They have access to healthcare. They can homeschool their children and are able to deal with that. But then there is a section of society who are really in a precarious position economically, but also in regards to for example, domestic violence. And I think that it is really important to keep in mind these different tools that I mentioned to really work on the questions of gender equality also during the COVID-19 times. Thank you. If there are any questions, I will be happy to answer. Thanks.
Дякую дуже, Мерві.
Thank you very much, Mervy.
Я власне хочу сказати,
I
що
would like to say that we have 10 minutes
для того, власне, щоб ми почали дискусію.
Our Q&A session for our discussion.
Якщо, власне, є питання, прошу
if there are some questions, please ask them in the chat.
Наразі я поки не бачу,
So far, I don't see any questions. I don't see any questions to Mervy, but Pavlo Pushkar would like to address you and to discuss the issue of gender equality and fulfillment of the decisions of the court. You have started this discussion. Maybe we can expand it, and maybe someone else from the speakers could respond to this. Pavlo, please. Yes, thank you very much. As we know, the problem of non-fulfillment of the decisions of national courts and the problem of rule of law as such and access to justice is the common problem. It is widespread, and there is one aspect in the light of our discussion. Do we have the research on do we have intersectoral research on the victims of failure to fulfill the court decisions? Some groups who is most affected by this. Can we say that most unprotected are some groups of people, including women? Could we discuss this, that we have some groups of victims which are the most common? Recently, I have heard the discussion by Amnesty International on the problems of domestic violence in the east of Ukraine. It is very interesting, and the report Amnesty International prepared is very interesting. It is limited by the region and it is limited by the topics, but some conclusions were interesting for considering and for further development. There is another point I would like to discuss from the perspective of case law of the Supreme Court. The decision of Levchuk is not final yet, so it is hard at this point to start these legal consequences in detail. But anyway, it was mentioned by Ms. Tatiana at the previous meeting, the factor of housing code. Ms. Tatiana, could you express this opinion? Because frankly, from the intellectual perspective, I really liked it as legal justification. Thank you very much, Pablo. Tatiana, please. Thank you for this opportunity. Indeed, Levchuk case is different from the cases, from the cohort of cases on domestic violence to which we're used to. This case was not about, it was not criminal, it was not about investigation, efficient or non-efficient investigation, but it was, in national practice, it was civil case, the eviction case based on Article 116 of the Housing Code. And what impressed me, and I used the chance having the presentation during the preparation training of the judges of the Supreme Court, I highlighted this problem just as raising the problem. The Housing Code is very outdated. It's very outdated law. I'm looking at the panel speakers. I can see Dmitro. He has his separate opinion on the decision, on one of the first decisions of the Great Chamber. He wrote that this is the only code which has the name Ukrainian Soviet Socialist Republic in its title, in Article 116 on eviction without providing of residential space. One of the conditions for eviction is violation of the rules of socialism cohabitation when other sanctions did not give the result. I'm quoting from the memory, and I was surprised that national courts, I monitored the practice that national courts do not quote this provision as the provision. They write the violation of rules of joint life, the violation of rules of cohabitation. They avoid the word socialist, but I believe that the concept which was built in by the legislator was the concept of 1983. It was Lenin ideas, registration, lack of rights for free movement, and it had to be analyzed from the perspective of this legal relations, of this systemic interpretation. No doubt that this problem cannot be solved by not noticing this word. And in the context of Levchuk case, this played the bad joke, and the bad joke was in particular with the Supreme Court, which reviewed the case in the Cassation Civil Court, reviewed it as cassation instance. And in this case, we have that the first instance made the decision on eviction, and the appellate instance rejected this, and the Cassation Court upheld this. When appellate and cassation instance courts, they did not see bringing of offender to the administrative responsibility, but they paid attention to violation of the rules of cohabitation in itself had to lead to eviction as the hardest way of losing the rights for housing by the individual, because there was no efficient, or there were no, the concept of Article 116, the violation of rules of socialist cohabitation, when are the sanctions. And what they discussed there is labor collectives and so on, the sanctions by the collective which existed at that time, they proved to be inefficient. And the lack of proof of efficiency of the sanctions, and if we don't notice, there is no bringing to responsibility. The administrative responsibility that was introduced by other laws and regulations much later. It led to this decision which we have. And in the context of the Lviv case, it is very interesting how the events will develop, because at least
in the situation that is described in the mass media, for example, in the interviews of the counsels for the defense, we can see the developments. And it seems that the applicant privatized part of the apartment that she owned. And she privatized, her children privatized their respective shares, but the perpetrator had to privatize his part of the apartment. And it actually links us to the case Irina Smirnova and some other cases, when events of life will affect the decision of the court, looking at how they develop, particularly when it comes to the social housing, when the tenants are not owners or co-owners of apartments. And now, catching up at what Pavlo had said, he recommended some pieces of literature and music. Speaking about domestic violence, I would refer to one of the most interesting series. It is called Little Big Lies, which shows this dynamics of gender-based violence, domestic violence in a seemingly very good family, well-to-do family, where their wealth and their social status and even the background, legal background of the victim does not protect her from being the victim, from falling prey to the perpetrator. Thank you, Tatiana. I've got a question about the video on the myths regarding the Istanbul Convention. You can access this video on the Council of Europe page. You can Google it, myths of the Istanbul Convention, and you will have a link to the page of the Council of Europe. It's a totally new, very recent video shot within this 16 days of Against Domestic Violence initiative. I would like to thank all the speakers for a wonderful, most informative session. And I will now invite all of us to listen to a very brief lecture by Professor Petro Rabinovich, who will speak about humanity as an object of legal protection. Thank you very much. Good afternoon, ladies and gentlemen, dear colleagues. Now, as the previous participant said, I will take the baton from her in discussing such human values as non-discrimination and countering domestic violence. I have thought that in the context of academic conferences, we can introduce the notion of an academic violence when one of the participants actually reserves the time, taking away time from other participants, thus depriving the audience of the right to ask questions, of the opportunity to ask questions. But that's apropos. My lecture brings this day to an end, and it actually thus makes me feel certain responsibility in that I had to think, how am I actually authorized, and do I have the right to be the last to speak? And I think that this great honor of myself can be described like this. Each human being should be the beginning and the destination point of any type of law. It's not my idea. It's the idea that was invented by a person who will be in the focus of my presentation. And if we speak about the formula, do not create a dummy for yourself. I still think that there are people who enjoy authority, deepest respect, and appreciation. And the words that I quoted belong to this very individual who formulated this tenet, that any human being is the beginning or the source and the destination point of any law. And he did not only speak about national law or international law or any section of the law, but the whole body of law. This idea was formulated in 44-45, right after the Second World War. And another argument by way of introduction. You say that history knows no accidents, but we see now that in a week, our department will be inaugurating, and Mr. Hudema will attend this ceremony. We will be inaugurating a memorial plaque to the former student of our department, law school of our university, who studied there 100 years ago, or even a bit more. And the products of whom, or the works of whom, on that very day of the inauguration of the commemoration plaque, we will witness the opening of the 75th session of the General Assembly, UN General Assembly, that will be discussing and I hope adopting for the first time ever a UN Convention on preventing crimes against humanity and liability for committing them. So this document, this instrument, has or defines 10 different elements of crime. And 4 of them were formulated by Hirsch Lauterbach personally when he, sitting in his office, dictated these ideas, 4 articles, 4 types of crime against humanity, to the chief of the team of American prosecutors who conducted investigation in early autumn of 1945 as part of the Nuremberg process. So in a week, these very provisions will be discussed by the UN General Assembly, and those will be the terms introduced by Hirsch Lauterpacht, former student of the law school in Lviv University. And thus, the UN General Assembly will commemorate him for the whole of the humankind. So this lecture of mine, or this presentation of mine, will be dedicated to him. And all of the previous presentations are in this or that way focused on the human being. And this is a cutting thesis of all of your presentation, and they actually link us with Hirsch Lauterpacht in this way. Another specific feature of this draft resolution, and the official title today is Draft Articles on Preventing Crimes Against Humanity and Liability for Committing them. So the drafters of this document, and I'll say a couple of words about them a bit later, so they didn't entitle this document yet, because it will be the mission of the UN General Assembly in a week from now. It will be on the agenda on the 15th of December this year. It's item 5 on the agenda. But the preliminary discussions were using this term convention. Whether the UN General Assembly will actually document it as a convention or any other act, it's up to them. It falls within their ambit. But the very idea to adopt such an act, and it won't be a declaration or a statement, it will be a conventional status instrument, because it will provide for certain remedies attached to it. And you know that Hirsch Lauterpacht was a practicing lawyer, so he insisted on the international bills on human rights should be associated with certain safeguards, certain remedies. So this brings Lauterpacht into the cohort of the most famous, most prominent legal professionals of the 20th century. Because not a single other legal professional would have these three basic actually merits and achievements that the humankind can be thankful to him for. Now, paying his due, I would again mention this commemorative plaque that we are going to inaugurate in the law school of Lviv Franko State University. So he drafted actually some of the articles, and 40% of the articles in the Universal Declaration of Human Rights will be consonant to his works, to his offices. In his book, published in 1949 in June, very few people know about it. 6 months before the Universal Declaration was adopted, In South America, the first ever regional, I would say, declaration of human rights and responsibilities was adopted by the Association of American States. Actually, 6 months before the Universal Declaration was adopted. But Lauterpacht had already published his book by that time. So summing up all of your presentations, I can say that they are dedicated to the human being. And very soon we will be listening to a dissertation on the integral interpretation of the law. So quite recently, I came to think that this integral word in the title can be explained that everything that is written or said about human rights should be linked to a person as a source and final destination of all law. If you look at it from this angle, then this very idea and this conclusion can claim some universality, as well as tomorrow's presentations will also focus on a human being in various dimensions, in various aspects of their rights. So this convention, I will still use this term to indicate it. I promised to give you more detail, but forgot all about it. I will return to it now. So you will know this new right to be forgotten, which is a totally innovative approach to human rights. So I've got the right to forget rather than to be forgotten. So I forgot to mention that this official document, because it's on the table of the UN General Assembly for consideration. So this text, can you imagine, has been translated into Ukrainian here in Ukraine. You understand that there are 5 official UN languages, and all documents, all instruments adopted by the UN are translated more or less simultaneously at the same time into these 5 official languages. And the first translation into the national language, official language of Ukraine, was carried out by my former PhD student, with my guidance, of course, and it was published in 2 periodicals in Kiev, in the legal newsletter of Ukraine. It was published there as an official draft of this convention, and another publication, internet outlet, reprinted this document. So it appeared twice in Ukrainian. So it was launched into actually independent navigation. So we do not claim that it's the best possible legal text in Ukrainian, but again, it is yet another instance of giving credit to Hirsch Lauterpacht, who studied in our law school, in our university. And we are proud to actually have a certain relation to his alma mater. A very non-trivial individual. So this draft convention has a preamble as usual. And a preamble actually describes the reasons and goals for adopting it. It says that crime against humanity exists, and until now, certain states remain unpunished because their criminal law does not provide, as matters stand, as a separate section, criminal culpability for crimes against humanity. And this impunity, the preamble reads, impedes bringing them to answer, bringing them to responsibility. And it is the obligation of the state to make them accountable, because crimes against humanity are the gravest international crimes. It's for the first time that crimes against humanity would be so qualified. The convention will have 15 articles, and the states that are going to ratify it should envision that in the context of the criminal law reform, the criminal culpability for the crimes, for the elements of crimes which were described for the first time ever by Lauterpacht in 1945 and dictated to the American prosecutors in Nuremberg. And the criminals on the criminals there in Nuremberg were charged with those elements of crime.
Польщі, а отже і всієї Галичини, яка керувала Львівщиною.
Including the person who was governing Lviv Oblast at the time. The main idea of the document is to oblige the national states to bring criminals to justice, to bring to justice those people who committed those acts, which were called as crimes against humanity by Lauterpacht. My time is exhausted. I still have 1.5 minutes. Mr. Professor, you have at least 2 to 3 minutes. Okay. So, Lauterpacht dictated 5 types of crimes at that time. The murder, the imprisonment, the deportation, the prosecution, the extermination, but 6th item which finished this list is the unique. Position of Lauterpacht, which opened this list. It made it open because 6th item in this 6th article of the Statute of Nuremberg Tribunal, to which Lauterpacht made the contribution, it says other inhumane acts. Inhumane acts, what is it? Inhumane acts, and then inhumane behavior, inhumane treatment. In the Declaration of the Human Rights, it is written, is copied into European Convention on Human Rights. What is prohibited is torture and other inhumane treatment or punishment which degrades human dignity. It is cross-cutting. It is the cross-cutting provision, and he made this list open. Other harsh, inhumane treatments of human population. This is how Lauterpacht finishes. And it's characteristic that in a Roman Statute of International Criminal Court in 1968, it is signed by more than 120 countries. It is signed by Ukraine in particular. Just imagine. The graduate of our faculty, of our schools, Zana Stanik, who at that time in 1968, in Rome, She was the Minister of Justice of Ukraine. I taught her our department. She was the one from Ukraine who signed this Roma statute, but Ukraine, Russia, United States did not ratify it. Why it is a separate matter. And in this Rome Statute of Rome, there is a special article, the crimes against humanity. It contains not 5 signs of crime, components of crime, but 10 components of crime, 2 causes. Because crimes against humanity were diversified. And the second reason, there is increase of demands, requirements for anti-human treatment, the lack of perception of anti-humane acts. And now in the statute of the International Criminal Court, there are 10 types of crime against humanity, and not 4 or 5 invented by Lauter Pact. They are recreated word for word, and there is also official, authentic author interpretation, what should be understood under the name of each crime. But those who developed the Rome Statute of International Criminal Court, they followed the example of Lauter Pact, but they didn't make this list of crimes against humanity closed. And they finished with item 11. After 10 types of crimes, they have item 11, which is the following: and other similar inhumane acts, atrocities, and there is no limitation that it happens only during hostilities. We don't have to have official war, which is officially declared during the peacetime. You cannot commit these acts which are believed to be crimes against humanity, and others similar. This word is used in the ICC statute. And what was done by the authors of the draft convention, they took it from the Rome Statute of ICC, they transferred this automatically, one to one, one for one, they copied this. This is Article 2 of the convention in the UN. It is soon to be discussed and approved. They copied all 11 types of crimes against humanity, which in 1968 were enshrined into the ICC statutes. The author of this document is the Commission of UN on International Law. The rapporteur, the special rapporteur of UN for this document, to prepare this document, is professor of one of the universities of the United States, George Washington University, Sean Humphrey, who just imagined 3 years ago, for the first time in his life, visited us at Lviv. In 2018, in October, here in Lviv, we had a unique conference of experts on international law, which was visited by the granddaughter of Lauter Pact, who lives in New York, and is Sean Humphrey, the organizer of preparation for this convention, which I'm discussing. He also came for the conference, and he gave the participants at the conference. There are more than 10 experts from different countries, the experts of international law mostly. And on the same day or on the next day in Lviv, we established 3 memorial plaques by the graduates of our legal department, which gained global recognition. First is Lauter Pact, number 2 is Rafael Lepskiv, who started our school after Lauter Pact left, and so on. The third lawyer, the author of the Global Convention of UN on Maritime Law. 3 memorial plaques after that event were installed, and this UN Convention on International Law during 5 years, over the 5 years, developed this document, which finally in December last year was included by the UN General Assembly into the agenda of the current 75th session of the UN, and we're looking forward to this on the 15th, On this day at our school, we will install, which was produced by the sculpture of the European level. It was the renowned artist of Ukraine and the Republic of Poland. With his participation, we will install the memorial plaque. Thank you very much for your attention. Thank you very much, Mr. Petra, for a very important turn with regard to the fact that we have to remember, we have to see the person. This is the basis of our human rights activism. It's the essence of our profession and the essence of law, to see the human. We're discussing cultural studies here, so to continue on what was mentioned by Mr. Professor, I'd like to draw your attention to the book by Philip Sands. If you haven't read it yet, it is available for several years. It was translated into Ukrainian. It was published by Old Lion Publication House, East-West Streets, coming back to Lviv. If you haven't read it yet, please use this opportunity. It's really important to read. Every person should read. If you're indifferent to the law and to humans, if you care, we have some changes in our agenda and we have to follow, we have to move forward. We have two presentations which cover institutional understanding of the decisions of the European Court for Human Rights. The members of the
have with us
Supreme Council of Justice will be speaking, and I'm grateful to Mr. Petra. I'd like to pass the floor to Larissa Shvetsova. Ms. Larissa will be speaking on the influence of the decision Kulikov and others versus Ukraine,
about how the decision
the
in the case Kulikov and others affected Serежа. Я уже здесь.
Supreme Court. Larissa, please. Thank you, dear colleagues.
Good
I'm very
afternoon.
pleased
It
to
is my great pleasure to participate
in this activity. I can tell you that indeed the topic which we will discuss today with Ms. Oksana for the Supreme Council of Justice and for the legal community, it is very important, it is very urgent, because it is interesting not only for judges but also for lawyers and all the community, because it's about
other
the
legal
access to
professionals.
justice.
It's my turn.
According to the provisions of Article 10 of the law in Ukraine on execution of the decisions and application of practice of the European courts, except for payouts and reimbursements, the additional measures of individual nature is restoration as much as possible of the previous legal status which the person had before the infringement of the convention. One of the types is the repetitive review of the case by the court. And so this excludes the restoration of proceeding on the case. And I can say that the case Kulikov and others versus Ukraine,
it is very important to judges because it is about the fulfillment of the function of by judges. And this case is studied by a lot of judges and counsels for the defense, so members of the bar. There is no clear mechanism of reinstating a judge in their position, even if the Supreme Court, while considering the case, would rule in their favor, because Part 4 of Article 124 of the law on justice and the status of judges should issue the order to restore the judges. And if we look at the decision, judgment Kulikov and others, it does not provide for the possibility to issue such a document. Now, speaking about the decision Volkov versus Ukraine and Polyakov versus Ukraine, in the former case, there are several specifics because it analyzed every stage of the dismissal and the violations in that. Violations by parliament and inconsistency between the law and the practice. And in the case Volkov versus Ukraine, you will know judgment was pronounced to reinstate that judge in his previous position. Kulikov and others versus Ukraine is different from the Volkov case in that it was about several judges, and it was a class action. And some of the applicants asked the ECTGR to have the Volkov precedent applied to them, saying that the right to life and individual safeguards should be the ground for their reinstatement in their positions. But in that case, a different judgment was made, and the ECTHR noted that the court cannot assess the effectiveness of the renewal of the
в частині розгляду справи Куліков та інші проти України. Справа була направлена на новий розгляд до Національного суду. І з цього приводу Вища рада правосуддя має велику кількість справ, які розглянуті як касаційним адміністративним судом, так і Великою палатою стосовно цього питання. Крім цього, хочу зазначити...
Also, I'd like to note on the criteria of admissibility applied by the European Court in the case Kulikov and others versus Ukraine. The European Court noted that usually 6-month term starts with the day of final decision in the process of exhausting the national remedies. However, in the case of applicants using the existing remedy, the applicant only later finds out the circumstances which caused the inefficiency of this remedy. What this demonstrates is that today the Supreme Council of Justice has the cases on review on which the Supreme Council of Justice made the decision to dismiss the judge back in 2010, 2011, 2012. So the cases which for a long time are in the condition when we have to decide the destiny of the judge, and we have to find out if there were grounds for bringing the judge to responsibility, holding the judge responsible. And in June 2020, the project of the Council of Europe for the support for execution of decisions by Ukraine in the context of Article 6 of the European Convention, together with the Supreme Council of Justice, we held the discussions of annual reports of the Supreme Council of Justice on the condition of ensuring the independence of judges of Ukraine. And also what was emphasized was that there are risks of new applications of applicants on the case Kulikov and others versus Ukraine due to long-term non-fulfillment of national remedies to fulfill this decision. Also, there are risks for additional applications in terms of the fact that making the decisions made will contradict the requirements of the convention on the terms of disciplinary sanctions. And in this regard, the Supreme Council of Justice has ongoing analysis of the Cassation Administrative Court and also the practice of the Great Chamber of the Supreme Court on review of this category of cases. I can say that we can see different application, different approaches in the Great Chamber to application of the provisions of national legislation on fulfillment of the decision Kulikov and others versus Ukraine, on the judges on whom there were decisions which were made, and in most cases these decisions are made by the Great Chamber based on separate opinions, and so on some cases the number of special opinions maybe about 10 or more. At the moment, we don't have unanimity of practice in terms of application of these norms, of these provisions. In this regard, some judges of the Great Chamber, expressing their special opinion, mentioned that it is necessary to have more specific attitude to the decisions of the Supreme Council of Justice based on the disciplinary cases review, and also give proper evaluation to the resolution of the Verkhovna Rada of Ukraine on the basis of which the appropriate decisions were made, because we know that the decision Kulikov and others versus Ukraine concerned the judges who were dismissed from the positions on the basis of the resolution of the Parliament of Ukraine, but 2 judges from were dismissed on the basis of the decree of the president. So any case, Kulikov and others versus Ukraine case, the difference of one and other is the difference. So now I cannot say that there is uniform case law of these category of cases. As regards, I'd like to say a couple of words on the fact that many cases which are applied to the Supreme Council of Justice are about potential presence in the actions of judges of the conflicts of interests, due to which the judges take recusals or recuse themselves. And in this regard, I'd like to note that in this case, the Supreme Council of Justice in its activity applies the practice of the European Court for Human Rights on the criteria for solving the matters of conflict of interests. This Polnovich versus Serbia case, where European Court notes the subjective and objective criteria which should be taken into account by the courts when reviewing the case in order to clarify if there is the conflict of interests and in which way the rights of individuals should be preserved for access to justice. As regards our practice on reviewing the case Kulikov and others versus Ukraine, all our decisions are contained at the website of the Supreme Council of Justice, and anyone has the chance to read them. So I will not go into more detail. I will not delay our distinguished participants, because I know that today we have very informative discussion, and I wish you all productive work, and I would like to pass the floor to my colleague, Ms. Oksana. Thank you. If there are questions, I will be happy to answer. Thank you, Larissa. Please, colleagues, you may write your questions in the chat. Now, for some reason, I don't see among the speaker panel Ms. Oksana. I don't see Oksana, although I have seen her about 10 or 15 minutes ago. Let's try to find out what happened. Is she connected? So will she come back to us? Because so far. I just cannot see her. Maybe there are questions to Ms. Larissa. There is a great opportunity to ask them now, and Larissa has the time to respond. While at this time I don't see Oksana, hopefully the colleagues will keep me in the loop and inform me whether we're waiting for Oksana or her circumstances changed. I can say that she's at work just like me. She participated, she follows the events, but I also cannot see her on the panel. And she mentioned that she connected as a listener, not as a speaker, so she doesn't have the opportunity to present. I have seen Oksana clearly as a speaker. Larissa, I'm sure that you know about Volkov case and its impact on your positions at the Supreme Council of Justice. You can say a couple of words if Oksana comes back. I believe that Oksana will get connected later. I can see that the decision on the case Volkov versus Ukraine was not executed at the Supreme Council of Justice because in this decision what was applied were individual remedies, the remedies of individual nature. And I can say that for the execution of decision of Volkov versus Ukraine,
було внесено зміни до і закону про судоустрій і статус суддів, і в 2017 році було прийнято закон про Вищу раду правосуддя в редакції, яка діє на теперішній час, і свідчить про те, що Вища рада правосуддя як конституційний орган відповідає всім критеріям, які застосовуються і Європейським судом, і Радою Європи до органів суддівського врядування. Тому ми знаємо, що суддя Волков був поновлений на посаді, і йому була виплачена відповідна компенсація.
Mr. Volkov was reinstated in his position, and this decision was communicated to the Council of Europe. And now it is not as topical and as acute as Kulikova and others versus Ukraine, because judgment in the latter case we consider this judgment on its merits, and we have 5 to 7 cases with judgments of the ECTHR regarding to Kulikov and others versus Ukraine. And once these decisions are taken, some of them may be challenged to the Grand Chamber. We are now looking forward to getting the case law of the Grand Chamber. I understand that the practices can be changing, and because the chamber membership has changed, and the decisions that we can see today are a bit different from the case law that used to be in the last 3 years when the chamber had different membership. But we will be monitoring their work and their decisions very closely. Thank you. Any questions? Thank you, Larissa. No questions. And I still don't know whether we have to wait for Oksana to join us. I don't have any data on this score. So now looking at the time, I understand that we have exhausted it, and we have exhausted our agenda. Perhaps Oksana will join in tomorrow and add whatever she wants to communicate to us. I would like to thank Larissa for stepping in. Oksana wrote to me that she's got some emergency. She has to develop the consultative opinion on a bill. So she extends her apologies to all of you, and she wishes success to your work. And she is sure that our exchange of opinions and ideas at such forums will enhance our knowledge, will improve cooperation, and will contribute to the quality of our decisions. Thank you very much. Thank you, OSCE and the Council of Europe, for putting together this event. Thank you very much. I would like to thank Larissa and all other speakers of today. And may I remind you that we meet at 10 tomorrow. We will be discussing the enforcement of the ECTHR judgments in Ukraine. And it usually cheers you up when you start your day full of hatred. And that's exactly what we are going to do tomorrow. You will be mobilized and you will be actually wide awake, I hope, at that time. So we will be discussing human rights tomorrow as today. Thank you very much for your attention. Bye-bye.